Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. My name is Vicki Henry, and I'm your panel chief today. My pronouns are she, her, and judge. I am delighted to be joined on my right by Judge Sachs and on my left by Judge Tan. You are welcome to share your pronouns or not as you see fit. We have 6 cases on for hearing this morning. We'll hear 3, we'll take a mid-morning break, and we'll resume for the other 3 in the appeals court. We have 15 minutes per side that's sometimes shared if there are multiple parties on one side. For better or for worse, we do not have rebuttal. I'm delighted to say we're joined today by some students, and I'm sure the lawyers are always great, but you know, you've got an extra incentive to shine here to inspire these students. And you will see sometimes that we all 3 of us have our devices ready to go. That's because we're largely paperless here, and so we have all of the briefs and materials and our notes on our iPads. So, you know, I'm not checking the stock market. If I'm looking over here, I'm usually looking at your material. Also, I just will say we are very familiar with the materials of the case. We say this every single time. I feel like people don't believe us. We sometimes know the record better than you do. So your 15 minutes is yours to use, interrupted by our questions, of course. But I encourage you to get to the heart of the matter. As one of my colleagues who's retired like to say, if you've hit a home run, you only need to go around the bases once. You don't need to go around a second time. With that, I'll call the first case. It's 2024 P1117, Commonwealth versus Smith.
Thank you. Good morning. Jennifer O'Brien for the defendant on appeal, Javier Smith. As you know, this is a single issue argument here, and that is whether or not there was sufficient evidence to find the defendant guilty of second-degree murder. There was not sufficient evidence. The Commonwealth went back and forth, I think, through the trial and in post-conviction as to what specifically Smith's role was in this. And ultimately, I think on appeal, the argument is that Smith, knowing somehow that his mere presence in the TGI Fridays would scare the victim enough to immediately leave the TGI Fridays, making him accessible for me to shoot, makes him guilty of second-degree murder. So assuming that that's the argument here, I'd like to address a couple of the Commonwealth's arguments and, with respect to, in some of the arguments made below and finding by the judge, by
so
2
counsel,
judges.
I do want to say that,
yes.
I mean, the Commonwealth is marshaling every bit of information it can in its favor as it should. And I want to make sure you're looking at it in the light most favorable to the Commonwealth, because they're saying it's far more than him going into the restaurant to possibly flush this other guy out of the restaurant to be murdered, right? They're saying that, you know, there was a huddle before he went in. He goes in, he's wearing a distinctive sweatshirt, and they're saying it was a warmish day, although on the video other people are also wearing long sleeves. And I'm past the teenage boy parenting stage, but, you know, and I don't know what the temperature is supposed to mean, because in February I'm begging them to not wear shorts when it's 0 degrees out. So what young male attire in the winter is really dodgy. But he also does this, he rushes headlong into traffic, he does this circuitous route, so he seems to come back to meet up with the vehicle. So it's a little bit more than him just walking into this restaurant.
Understandable, and agree, Your Honor. With respect to the sweatshirt, the Commonwealth has argued, you know, below in the trial court that the sweatshirt was put on to be conspicuous so nobody would really recognize him, and he had his hood up. But on appeal, they're arguing that he has this, you know, Where's Waldo striped sweatshirt where it makes it so people can see him. So I'd say that the Commonwealth really can't have that both ways. It was a spontaneous decision by the victim and his girlfriend to go to the Fridays to have French fries. They were en route somewhere else, and the girlfriend was driving a rent-a-car. So, you know, arguably, there's no evidence that they were being followed by this red Jeep, but she was in a car that wasn't her own. If it was spontaneous, assuming that the defendant got dressed in the morning, there's no,
That's another questionable assumption with, I mean,
this-
many people have a wardrobe, other people have a cardrobe, and they leave, you know, a
so if
locker
there's a
room in their car.
sweatshirt, I would argue, which is it? Is he putting on a striped sweatshirt so he will be noticeable running away, which he wasn't noticeable running away because the Jeep had taken off, or is he wearing a sweatshirt because he doesn't want anybody to know his identity? Again, and this is the problem with this case, it's piling on, inference upon inference. So I just say that the Commonwealth really can't have that both ways. As far as running into traffic, could that show that he knew that something was going to happen? Sure. That there was going to be trouble? Was there evidence that there was going to be a shooting or that Meade was going to try to kill the victim? No. I mean,
What about the Commonwealth's argument that because Meade was 100 pounds less than the defendant, that the only way Meade was confronting him was if he had a gun?
I think that's a little bit unreasonable. There are fights all the time where small guys fight big guys, and sometimes the small guys win. To say that just because somebody is smaller than somebody, he has to be armed with a weapon necessarily, I think is just too far. I would note also that the defendant was 5'8", 150 pounds, so he was a small guy as well. So if the Commonwealth wants to argue that size matters here, if Smith went into a restaurant and he's only 5'8", 150 pounds and much smaller than the victim in this case, why would he ever think that the victim would be afraid of him and run away? We're missing that piece. We're missing the piece where Smith would have known just by showing his face that this victim would be so frightened that he would immediately leave the TGI Fridays.
There's consciousness of guilt too, right? So not only is there flight, and the video shows he's really running across a really busy street, Tremont, I believe, right?
Absolutely.
And then not only that, but right after the shooting, there's video that shows him walking a few blocks down from the restaurant, from TGIF, and he does this halfway down the street, right? Then crosses the street, then turns back around and goes down comes back, right, on the other
Yes.
side of the sidewalk, turns and goes, I think, towards Brigham Circle, towards the TGIF, and then less than maybe 2 minutes later, there's video showing him coming back down Tremont, going the other way, and also sort of looking, turning around and looking around and looking behind him.
Yes.
And he's stopped by an officer who's responding to the scene, right? And he's
Yes.
questioned, and he says, yes, I was at the Tremont House of Pizza, but I didn't get anything to eat because it was too crowded, it was too busy. And then a month later, he's questioned again by police, and then he changes his story and says,
Yes.
no, I actually sat down and I did have some pizza. So isn't that, and I know you say that they're piling on, but isn't that all of these things taken together?
Yes, there is consciousness of guilt. I'm not going to dispute that. I did have an argument, obviously, for behind not, a young black male in Boston not necessarily cooperating with the police, why he might have taken his sweatshirt off. But if this court isn't buying any of those arguments and said there was consciousness of guilt, I would ask the court, consciousness of guilt of what? Is there proof that he knew that Meade was going to shoot the victim in this case? Guilty? Could he know that something was going down, that a fist fight might have happened, or when he saw police cars know that something happened and was curious and just staying around the area? Did he run because the victim is much bigger than him and the victim spotted him? I think there is consciousness of guilt here, but again, to say that he ran because he knew that Meade had a gun, was going to shoot the victim, and him showing his face was going to make the victim turn around and run into Meade is just too many inferences.
Right, but there was video again, right before the shooting that shows him in the car, in the red Jeep,
Yes.
with Meade, right, getting out and then appearing in the TGIF right shortly after, right? And then leaving, and then the shooting happens just, is it 20 seconds, I think, after?
After Smith leaves. I dispute the Commonwealth's characterization of the people in the car were huddled or having some sort of conference. They're stopped at a red light.
They're in the car, though,
They're in the
together.
car together, absolutely. They're in the car together. They're stopped at a red light. There's a car in front of them. The car moves. They take off. They don't wait. I mean, and I would look at, all the cases that we have that we've cited, and I think the Commonwealth has cited as well. I mean, a joint venturer has much more of a role in any of these shootings. I mean, whether they're providing a gun or being the getaway driver, I mean, this defendant he walked, even if I'm not conceding anything as far as him knowing what Meade's intent was. That wasn't proven at all. But if he knew that something was going down, that's not enough for conviction.
Can we, as I saw the video of him getting out of the car, it appeared to me that he was tugging his sweatshirt on, that he was pulling the bottom of it down as if he just put it on in the car, which suggests to me that he was trying to conceal his identity, at least for so long as he went into the TGIF. Then he comes out and runs. But can't we infer from that, or couldn't a rational jury infer from that, that he knew something bad was going to happen, that he could be blamed for it or was going to be culpable somehow, so that he concealed his identity? And that his running was, you could say he ran either because he was afraid of the victim, who he didn't expect to find there, or because he knew that something bad was going to happen that was going to threaten his own personal safety if he didn't get out of there.
Again, we're speculating, right? And that's what the problem is. There could be many different scenarios. How would he ever?
If he was concealing his identity when he went in, then doesn't that suggest that he already knew something was going to happen? He knew that the victim was going to be in there.
Well, I think your question is spot on, but something was going to happen isn't necessarily that somebody was going to be.
Something that he was scared of that made him, as soon as he saw the defendant, or the victim, of running out into traffic and really kind of taking his own life into his hands in that way.
But if he knew
to get out of the way of something that was going to be more threatening to him, like gunplay of some sort.
Well, wouldn't you, if this was anybody's child and they knew, if this was your son and he was going into a restaurant and knew that something was go down, wouldn't you tell him always run away to leave? If he knew something was going to go down, he ran. Why didn't he?
Why go in there in the first place?
Why go in there in the first place?
Why conceal your identity and go in?
Maybe he's just being a busybody. I don't know. I mean, what was his meaningful participation? There's no question that he put on a sweatshirt, he put on a hood, and he went into that restaurant. Where is the meaningful participation? How could, if his job was to locate this person and then tell the others where he was, he never did that. And it would have been, he left before. The big problem is he left before. I'm sorry to cut you off.
No, I agree. It's hard to see how he informed the shooter of where the victim went.
Yes.
I mean, there are a lot of things that we don't know, but it's clear that the shooter knew that the victim had gone back to the parking lot, because the shooter didn't go into TGIF to look for him there. He went right up the stairs after him, and
yes.
That was like a minute afterwards.
I think the Commonwealth at best proved that the defendant was with the shooter prior to, that he went into the restaurant, that he knew something might be going down, but what? And why would his appearance make the victim leave that restaurant? I know the Commonwealth uses, like here we're looking at the state of mind of the defendant, right, in a joint venture to see what his shared intent was if he did have shared intent. The statements, there are no statements made by the defendant. The defendant made no gestures. He didn't have a gun with his finger or a gesture in any way. The Commonwealth argued in its closing that the defendant eyeballed the victim,
but evidently
looked at
that was
the victim.
Enough, because we know that the victim's girlfriend, or its victim's girlfriend, says the victim said, "Oh, he's from the block, babe. We got to go." And he leaves 20 seconds later. So
absolutely, but where's the evidence of the pre-existing hostility? I would ask you that. And secondly, the statement by the victim saying he's from the block, we got to go. That goes to the victim's state of mind, not the defendant's state of mind. Maybe the defendant was thinking, he's from the block, I got to go. We don't know what he was thinking. They're trying to impute the statements of others onto the defendant. Same with the statement by Meade when he says, "You're the ops." Where is the connection that because the victim was the ops to Meade and there was hostility, that the victim was the ops to Smith and Smith had the same hostility to Meade just because they were in a car together earlier? Where is that connection that they were the ops? There was no gang evidence introduced. The Commonwealth chose not to introduce any gang evidence, so there was nothing like that here, where there was a prior, there was evidence of a prior conflict between the two of them, that even though Smith was much smaller than the victim, that he knew that by seeing the victim that he had to get out of there.
So,
I mean,
does
yes.
the record establish how much time elapsed between when the victim went into the restaurant and when the defendant went into the restaurant? It's sort of the compilation video that's not so clear.
Yes, so I believe it's 12:07, that it's a couple of minutes, I'm sorry, it's about 7 minutes later. And the Commonwealth can correct me if I'm wrong. I think it's about 7 minutes later that the defendant goes into the restaurant. He stays for about 20 seconds, then he leaves, and then it's about 20 to 25 seconds that the victim leaves. And after the victim gets to the parking lot, it's about 20 seconds before Meade shoots him. So it is very, very close in time, absolutely. I'm not, suggesting otherwise. But again, the closeness in time, where there are, it doesn't mean that the defendant shared the intent to do an act where a plain and strong likelihood that death would result. There are just too many uncertainties. There are so many things that the victim could have done if he was afraid of Smith, including staying in the restaurant, calling for help, calling the police. Maybe he thought since Smith had left, he was all set. Sorry, I see I'm out of time. Unless there are any further questions, I'll just rest on my brief. Thank you.
Thank you.
Thank you very much. Good morning. May it please the court. My name is Kenneth Steinfield, and I am appearing today on behalf of the Commonwealth of Massachusetts. I'd like to focus the court's attention on the extreme narrowness of the time frame of all the activity in this case. The Jeep pulls up 5 minutes and 7 seconds after the victim goes into PGIF. They stay in the car for 50 seconds. 50 seconds after Smith leaves the car, he leaves PGIF. After Smith leaves TGIF, 34 seconds later, Meade leaves the Jeep from the other side of the plaza.
Okay, so let's just stop right there.
Right. And I should have included a chart. I realize it in my brief. It might have made things easier.
I love charts.
I know.
Some defense attorneys even put out on Twitter how much I love charts, so I'll say I love charts.
Yeah.
Very helpful.
Yeah.
But if we were to have a chart of the defendant's knowledge that Meade had a gun, what evidence is there that he knew Meade had a gun?
Well, first, my point was that it was so concentrated. The shooting occurred 98 seconds after Smith left the restaurant. And that shows that this was a highly choreographed, concentrated effort by both of them. And the fact that the extent of the violence itself, first of all, was so extreme. He emptied a full 17 shots.
I know there's a lot of drama here, and I watched that video, and I thought I really should write down how many murders I've now watched on video. But let's leave, that's for the jury. We're the dispassionate. What's the evidence he knew he had of the gun? What do we, because that's the case hinges on that.
Well, I think the extremity of his flight shows that he knew something terrible was going to go on. I've never seen anyone run like that through traffic right afterwards. And I think that goes to show very strongly that he knew that something very...
But her response back is, well, there's an equal innocent explanation, which was he saw a guy in the opposition, and he's much smaller, and he got the heck out of there, except he didn't because he...
But there's one flaw to that.
Okay.
When he leaves TGIF's, he walks to Calumet Street. He only begins to run when he gets to Calumet Street and doesn't see the red Jeep there. So if he were so afraid of the victim, he would have run out of TGIFs. He only starts to run when he's at the corner with Calumet, when he realizes the Jeep's not here. Then he takes off across Calumet and does what I said. It would be a lot more plausible if he'd started to run right after he left TGIFs, but he doesn't. And of course, he has concealed himself before and all that. And the way he hurled himself pell-mell through traffic, but that was only after he'd reached that corner. And I think that's a very important point. And of course, the clothing that he's wearing, he wants to hide himself. And
Oh, no,
the
that
question
sweatshirt is the opposite of hiding himself.
well, but
It probably comes in second in 10 years of outfits that reveals themselves. I had a case where a guy was wearing a foot-high hashtag on his shirt. That guy was easy to follow. This guy was very much.
Of course, I've had cases where defendants have worn such distinctive T-shirts, I don't know what they're thinking.
It's true.
Commonwealth's view here, though, is that that T-shirt was distinctive so that Meade would see him leave, would know that he had left the plaza, because they were parked on the other side of the plaza. So the distinctiveness of the sweatshirt was for Meade.
Yeah, but what is, that's the part that doesn't necessarily make sense, and you're not sitting down until we answer that gun question. But Meade doesn't need to see him leave. Meade just needs to know he went in the restaurant. That's it, right? And he's not looking for the defendant to leave the restaurant. He's looking for the victim to leave the restaurant.
But Meade's not there when Smith goes into Fridays. He's gone down Calumet. I'm sorry, gone around and then up Tremont. He never sees Smith go into Fridays. He's got to make sure that Smith has left Friday so that he can see him leave, so he knows. And there may have been a signal we don't know. I have to admit that there's a lot of questions that are not answered that we would love to have answers to. But of course, in every trial, there are cases that are not answered. And of course, the inferences have to be reasonable. They don't have to be more logical, less logical. It's just a reasonable inference.
Right, but we need to know, don't we, or tell me if we don't, that they shared some sort of lethal intent or at least some intent that there was going to be an attack. And it's particularly the gun. What's the evidence that he knew Meade had a gun?
Well, in the Robinson case, it talks about having an opportunity to see a gun in the moments right before, and I would argue that in the car he had an opportunity. Of course, there's no evidence of exactly what happened in that car. But the weight point that I was making is not between Smith and the victim's weight. The weight differential is between Meade and the victim. Meade was shorter and weighed a lot less than the victim,
right.
100 pounds. The victim was more than 100 pounds more than Meade.
Right,
so
but I'm back at the gun. So the evidence that he knew he had a gun was that they were in a car, they knew each other and they were in a car together, and that the defendant arguably went in to flush the victim out of the restaurant. Is there any other evidence? I want to hear, because that's what I'm seeing. Is there more?
No, it's a very circumstantial case, but I think that it's tight enough, and it's not a piling of inference upon conjecture or speculation. I argue it's an addition of reasonable inference to reasonable inference to reasonable inferences.
Do you need to show that the defendant knew Meade had a gun, or just that the defendant knew that Meade was going to do something that created a plain and strong likelihood of death?
The latter, and thank you. I'd actually planned to argue that way beginning, but then I got off track. That's precisely what the standard is here. That's why I think the phrase lethal intent is not that helpful, because here we are talking about third-pronged intent. So the Commonwealth just had to show that in the circumstances known to this defendant, a reasonable person would have known that his actions created a plain and substantial likelihood of death. Here, though, it seems the only way that that could happen would be through use of some kind of a weapon, a knife, a gun, something like that. But you're right, it doesn't have to be knowledge of a gun. This is not a case where, like a felony murder case in which it involves an armed crime, where you have to show that he knew that there was a gun. That's not this case. We just have to show that he shared the intent of malice. And of course, Meade's malice was first and second prong, and third as well, I think. But as to Smith, it was only third prong malice. So that's correct. You don't have to show that. But I think that the fact that what actually happened is some evidence of what was intended to happen. And given the time that they spent together, I really think those 50 seconds in the car, and by the way, they're not stopped at a red light. They're pulled over. They pull over onto the curb as close to fighters as they can. You can't see if there's a red light or not. There may be, but they have pulled all the way over, so they are as close as possible, and they remain there for 50 seconds. These three men in the car, there's no dispute that Meade and Smith and Gill are in that car for 50 seconds.
Do they remain there after the car in front of them proceeds on ahead? I can't recall now.
They do, but it's right after Smith
Gets out.
leaves the car.
Okay.
So as soon as he's out, they're gone. But that 50 seconds, it's not that they're just in traffic. They pulled over out of traffic. So something happens in those 50 seconds. And like 2 minutes and 28 minutes later, the victim is shot and killed.
Were the individual videos introduced as evidence or only the composite video?
I believe there was some raw footage that was also introduced. I honestly do not know. But we focused, the ADA at trial, both in its opening and its closing, focused on the composite. But I do think there was other raw footage.
You said that the defendant didn't start to run until he got to Calumet Street and didn't see the red Jeep there. From the composite, it's, I don't recall it being 100% clear exactly when he started to run.
Well, I think, and I'm pretty
Maybe
sure that
high up, grainy footage would show that.
it shows, well, it's not so grainy. There is footage from the plaza that shows when the defendant left TGIF, it was 12:07:56. And there's a fairly clear shot of the plaza that shows the entrance to TGIF, and it shows him coming out.
Running then, I agree.
Right.
Then there's the higher up shot of all of Brigham Circle.
Right, right, that showed-
Poor quality video, and you can see him running out across Huntington Ave and then sort of inbound on the green line, but it's not clear when he started to run.
Oh, there's a shot, I think it is clear, because there's a shot from the plaza camera that has the yellow timestamp on it when he gets to the corner. It's a shot down, down Calumet Street towards the circle that shows him arriving. It is just before it goes to the poor quality video that shows him getting to the point where the red Jeep had been. So I think it does show the moment that he began running was when he reached that corner and sees that there's nothing there, and then he bolts straight across Calumet. Then, as I said, he turns right, and then another right, and goes down Huntington at a pace. And in closing, his attorney suggested that he was chasing a bicycle in front of him, and that's why he ran so fast down Huntington. And if you look at the video, there is, although it's kind of shadowy, there is something in front of him that is a bicycle. But why in the world would a defendant or a person who had just done what he had done decide at that moment, oh, I'm going to run through down Huntington Ave at this rate, at this pace, and chase a bicycle? It just doesn't make sense. He's running like that because of his knowledge of the extremity of the violence that he knows is going to happen before, which would almost necessarily involve a firearm.
So, because I noticed too, that I would have thought, what I thought there was another person running in front of him on Huntington. You're saying that was a person on a bicycle?
Yes, it is. And I think that if you look at the tape over and over and over again, you will see a bicycle. At first, I was confused as to which is which. Is he the one in front? Is he in back? But if you read the closing argument of defense counsel, I think he accurately portrays it by saying he was chasing a bicycle. So, yeah, I think that's one of those things that takes repeated viewings. Obviously, we all know that these, you have to watch it over and over and over again to get the nuances and see who's who. And there are two red cars, that are going around Brigham Circle, so you have to figure out which is the, Gill's car and which is not. But, yeah, it's definitely he's chasing a bicycle, and he gets closer to it. I mean, because he's running so fast.
There are two red cars?
Yes, there's one in front of them when he stops on Calumet. There's another red car, and then the shot, that overhead shot that shows him going around the circle, shows the other red car going first, and then it shows Gill's Jeep going around.
Other red car is?
Another red car is just a car that annoyingly happens. And also on Tremont Street later, going the other way, there also happens to be another red car. So figuring out which red car is Gill's is not the easiest thing to do, but it can be done, as I said, if you watch the tape repeatedly.
Is there a map in the record of his circuitous route? Because I didn't see one, but I didn't look
Well, there's
at
a map that has the streets, and
nothing that shows, you know, like a little, you know, traces his path.
no, but in the supplemental record appendix, there's a larger street map that shows all the streets that are mentioned. And I suggest that if you read the text of my brief, I go down, I basically tell you that if you have that map right there, you can very easily trace where he goes and how he comes back around and then goes down Tremont. And then, as Justice Tan pointed out, makes this bizarre circuitous, takes it right onto St. Alphonsus, and he comes back and he goes up and then he comes back down. So, no, there's nothing in the record that shows that, but I think if you use that street map and follow along with the facts of the brief, then you can do it
So she
yourself.
says there was no gang evidence introduced. Is that correct, other than the ops?
Yeah, well, there is, he's from the
Block.
which may or may not be. There was no gang evidence. I do not know. I know that my sister has said that the couple chose not to use it. I'm not sure whether that's true at all. There's nothing in the record.
Let me get to what I really want to get to,
Sure.
which is that what evidence was there to support that the victim would have or should have feared the defendant? Other than he's from the block
Well,
and is,
the evidence was that he did fear him.
okay.
And that's more important, and I think it's important to keep in mind that when the victim arrived at the restaurant, he was in an extremely good mood. You see him sliding down the stairwell, sliding down the railings when they're going down the stairs while his girlfriend is walking down, sort of looking at him like, you know, what are you doing, you big kid? And then he sees his friend Demetrius, he gives him a greeting, he goes, and he's in a very good mood. The evidence supports that. And just a few seconds later, it's boom. Smith walks into the restaurant, he sees him, and he says, babe, we gotta go, he's from the hood. So that evinces a hostility, a pre-existing hostility between Smith and the victim. And he acts on it immediately. And as he leaves, you can see how nervous he is. He's looking around the plaza, he's pointing, and they go straight back to the car. So I think that's that evidence on that point. Now, is there some question that I have not answered? Because you said you wouldn't let me sit down until I'd answered it, and I wasn't sure I had.
I very well argued on both sides. Thank you very much. I think we understand your positions and the cases submitted.
Thank you very much, Your Honor.
Our next case is 2025P0015. I also don't think I said the date this morning. It's the November 7th, 2025 sitting. Commonwealth versus Steward. And I think we're hearing from Attorney Rogers first.
Good morning. May it please the Court. Flannery Rogers on behalf of Josiah Steward. This interlocutory appeal presents questions about the lawfulness of police conduct during a traffic stop for an inspection violation. This Court should reverse the order of the trial court and allow Mr. Stewart's motion to suppress because the police violated Mr. Stewart's constitutional rights at every step of the traffic stop. I want to address each of those violations in turn because each decision the police officer made represents an increasingly serious intrusion into Mr. Stewart's liberty, intrusions on his liberty that the Commonwealth failed to justify. I'd like to stop, let's just say that neither the exit order nor the frisk of Mr. Stewart were justified.
So I just want to jump in because there's a lot of different decision points along the way that I'm sure both sides want to address, as do we. So does the police officer get to order the defendant out of the car based on his observation of the defendant's, sort of moving around and sort of looking nervous, and the driver looking nervous as well? Does that and the judge is finding that the officer felt for safety that does he get to order him out of the car? And then therefore pat frisk him?
So the answer is no, Your Honor. The officer's belief that his safety was at risk was not reasonable based on simply the testimony, the officer's belief that the passenger and that Mr. Stewart and the driver were nervous, in combination with Mr. Stewart's movements in the car. So I do want to address Commonwealth v. Meneed, which is the case that the Commonwealth relies on in its brief. And that case is distinguishable for a number of reasons. I would start by just saying that that case, the dispositive issue, was not the exit order or the pat frisk. It was rather the scope of the protective sweep of the car. I would also add that the case of Meneed was decided in 2016, so some time before Torres-Pagan, where the Supreme Judicial Court clarified those two standards. And in Commonwealth v. Meneed, that exit order and frisk are, in fact, analyzed, I think, together. But thirdly, and perhaps the most important distinction, is the factual distinction. So the stop of the car in Commonwealth v. Meneed happened late at night. It happened in a neighborhood that Commonwealth knew was known for drug activity. When the police officer stopped that car, he smelled the aroma of unburnt for fresh marijuana coupled with the strong scent of air fresheners. And the police officer testified, and the judge found in that case that his experience that was indicative of marijuana distribution. So already we have some other indicia of criminality. And I think that alone wouldn't be enough. This court and the SJC has said that indicia of drug activity isn't enough for an exit order. But that coupled with that extra factual finding coupled with the movements.
So you think that both him and the driver being very nervous and him moving around, seemingly reaching perhaps under himself or behind himself, is not enough for an exit order? Okay,
So I want to take both of those in turn. Your honors have the body-worn camera video, and you can look at that and review it de novo. So I think it is true that the body-worn camera does not show Mr. Stewart very well, but the description during the motion hearing was that he was seated with his hands on his knees facing forward. So that can be interpreted many ways, but Judge, I would suggest that if Mr. Stewart had been fidgeting or if he had been breathing heavily, then the officer would have interpreted that as nervousness too. And in fact,
that may not have been particularly suspicious, but what about when he rises up out of the seat?
Yeah, so I actually don't think the testimony on that is really detailed enough. So the testimony is that he shifts his body from the left to the right. We don't know how far up, so certainly there's no testimony that his hand was going under his rear end or toward the floor. All we have is the testimony that he shifted from left to right. But what we do have, and this I think is the crucial piece, is the body-worn camera showing that when the officer approached the passenger door, opened the door, Mr. Stewart's sitting there with his seatbelt on and his cell phone in his right hand. I think the through line here is whether or not the exit order and then the pat frisk were objectively reasonable.
But the judge also found, right, that the officer observed the defendant tapping his pocket, too.
Yes, and I don't think that adds anything to the calculus, Justice Tan. It's a bit of nervousness has been found by this court and the SJC to be common during an interaction with the police, especially in this case where Mr. Stewart is a young black man. The fact, just to return to the cell phone and the movements, this is a traffic stop, so everyone in the car can anticipate that when the officer returns to his cruiser, there's going to be a moment, probably a few minutes, until the officer can run that information from the license plate. And I think it is just about instinctual now for every person who has a cell phone when there's a period of time while we're waiting to pull out our phone and take a look at it.
Okay, but let's assume, because there are plenty of cases, including Goey, that say just because there could be an innocent explanation, the police don't have to assume that. They can still assume maybe there's a risk to them. There's another case where they come back and the guy's smoking, and there's like, well, he could also smoke and be getting a gun at the same time. So let's assume the exit order was okay, and the pat frisk, all it reveals is that he had $1,200, or that he had money. Let's assume for a moment even that I'm not sure why the police can take the money out of his pocket when it's supposed to be a safety check. We're pretending it's a safety check here, because let's face it, this officer was looking for drugs. So now he's out of the car, he's done a pat frisk, we know he has money, maybe even a lot of money. So at that point where the frisk has revealed no weapon, okay, and the check of the passenger area has revealed no weapon, what allows, but the police officer says he has reasonable, first of all, actually, do you agree it's reasonable suspicion is the standard? Because the Commonwealth goes back and forth between reasonable suspicion and probable cause.
Reasonable suspicion to believe that he's armed and dangerous, is that?
Well, there's both, that's been dispelled. So now is there reasonable suspicion that a criminal activity is afoot, in this case, drugs?
No, I do not believe so, Judge.
Okay. And go ahead.
I mean, and certainly not probable cause, which would have been required for the then continued detention.
But breaking this down, so the police officer says that he's got a lot of money in cash, and he sees a corner of a bag somewhere in that passenger area, and he's nervous before he's pulled out of the car. He is cool as a cucumber after he's pulled out of the car. What else do we have? Are there other factors? We shouldn't be disagreeing about the facts at this point. We should be focused on the law.
Well, I don't think that the amount of money that Mr. Stewart has can be factored in. I think the fact that he had currency, period, which is, I don't believe, adds anything to the calculus of reasonable suspicion. As regards to this plastic bag on the seat of the truck, I think if the Commonwealth wanted to rely on that, they needed to do more at the motion hearing to elicit from the officer why he believed that plastic bag had some sort of criminal, some indicia of criminal activity to it.
It was never entered, there's no evidence in the record, right, that the officer ever seized it, entered it into evidence. It was never marked as an exhibit, correct? So we have no idea other than he says he saw it there, right?
Correct.
That's all we have. We know nothing else about it. No one ever, is that correct?
That's correct, Judge. And I think the law says, Commonwealth v. Garcia, Commonwealth v. Alvarado, which are, well, Commonwealth v. Garcia is cited in Commonwealth v. Torres, a much more recent case from this court, that these types of benign objects that can have illicit uses, but also have licit uses, there needs to be more adduced at the hearing to show that they are being used for an illicit purpose at that time.
So the corner of the bag, for a moment, I'm actually not joking here, the only legal usage I know for people cutting off the corner of a plastic bag is to ice a cake. That's what you put icing in, you squeeze it through. Is there some other legal use you know of besides, because usually it's just to package drugs?
Well, we just don't know enough about this piece of plastic bag, Justice Henry. It could be,
I don't know, is there some electrician use? Because the driver's an electrician.
I don't know. It could simply be trash.
All right, but let's assume for a moment you have the nervousness, you have the movement, furtive or otherwise, where he's shifting from one side to the other side. You have the $1,240 in cash. You have a cut corner of a bag, assuming we have that. At that point, assuming the officer could, but the officer did actually frisk the guy and didn't find any drugs, and he did frisk the passenger area of the car and he didn't find any drugs. At that point, is there any basis for further inquiry? You're going to say no. Let's assume we don't agree with you for a moment. At that point, can the officer walk a dog by that guy? Is there any? So
this is not a question addressed by my argument by this case. I don't believe. But if you're asking if I believe that a dog sniff is a search, my answer would be yes. I think the court does not.
Feyenoord says a dog walking by a car is not a search.
Of course.
Is there anything that says whether walking a dog by a person is a search?
This jurisdiction has not addressed the issue, and nor has the Supreme Court. I only know of one jurisdiction that has answered the question that yes, a dog sniff of a human body is a search, and that's New York. But the reason I don't think this court needs to answer that question is because, at that stage in this encounter, where Mr. Stewart gives his consent to produce the drugs. The issue is whether or not that consent is valid, or whether there was any implicit or explicit coercion. So the threat of the dog sniff is just one factor among many that made that consent invalid.
Can I back up to the moment between the exit order and the pat frisk? Assume, and I know you argue otherwise, that there was justification for the exit order. Was more needed to justify the pat frisk?
Yes, yes, absolutely. So I know that there are situations where the same facts can justify an exit order that justify a pat frisk, but there are just so few facts in this record, and none of those facts indicate that Mr. Stewart was both armed and dangerous.
So let's assume that the upward motion of the defendant that the officer observed when he was back in the cruiser gave him some reasonable suspicion that the defendant was reaching for a weapon or concealing a weapon. Let's just assume that.
Okay.
Does that equate to the defendant being dangerous?
Well, it's pretty hard for me to make that, to go along with that assumption when the facts are that the door was opened and Mr. Stewart was holding a cell phone, not a weapon. So assuming then an exit order was justified, Mr. Stewart's out of the car, still not holding a weapon, and there's no weapon in the car. And I want to just pause here because I think one of the things that makes this officer's belief not objectively reasonable is the fact that the driver is allowed to remain in that truck throughout the entire encounter. So I can't see how the officer's stated belief that there might have been a weapon in the car is objectively reasonable on these facts.
So the fruit of the pat frisk is the money. And whether he took it out of the defendant's pocket, he said he knew it was money as soon as he felt it there. So
Right.
the taking it out and looking at it a couple times doesn't really seem to change things that much. But how did the knowledge of the money then make the drugs the fruit of the, what you're arguing is the unlawful pat frisk?
I'm sorry, can I restate the question and see if that's
Sure.
correct? How does the seizure of the money?
How does the knowledge of the money, forget the seizure, but he knows there's money because he does the pat frisk and feels it there. How does that mean that the discovery of the drugs is the fruit of that pat frisk?
Well, so the discovery of the money, and I guess I'm sort of resting on the actual search of Mr. Stewart's pockets, the pulling out, that exceeds the scope of the pat frisk, the lawfulness of the pat frisk. And so just right there, that's an intrusion on his liberty that's not justified by any means, and it should have ended.
Well, but how did that removal of the money from the pocket lead to the discovery of the drugs any more than feeling the money in the pocket did?
No, I guess I don't think the discovery of the money led to the discovery of the drugs. It was simply one more step in this prolonged detention that was not supported by probable cause. And I mean, maybe I would just answer this by saying that, Commonwealth v. Tavares states that, after a constitutional violation in an encounter like this, all evidence discovered thereafter should be suppressed. So I'm sorry if I'm not answering your question.
Well, I think we're getting to sort of, inevitable discovery or independent source issues that haven't been briefed.
Yeah, okay, if they haven't been briefed, I'll stop there.
All right, where do you think is the strongest point where there was a violation and then everything that flowed after is suppressed?
You're not giving up any of your other arguments.
Yeah, I think that's a pretty hard question for me to answer, Justice Henry. I really do think that there was not even any objective belief of safety, but I understand that, and I'm out of time. You can please shut me off if I understand what the court said earlier about, that officer safety, they shouldn't have to take chances. But I want to remember that that's a policy argument, not a statement of black letter law. So they don't have to take chances, but they still have to have these specific objective facts to support their reasonable belief.
Okay, I think we understand your position. Any other questions? Thank you very much.
Thank you very much.
We'll hear from the Commonwealth.
Good morning. May it please the Court. Elizabeth Sweeney for the Commonwealth. Viewing this suppression matter under the deferential standard of review, the record, including the body camera, fully supports the motion judge's determination that the experienced detective's actions were lawful and reasonable and proportionate in this matter, as it's a very fluid drug investigation as it's unfolding. Every step was driven by safety and evolving facts, not a hunch or coercion, and his choices were measured. Beginning first with the exit order, this was a lawful vehicle stop. The officer observed nervousness of both the driver and the passenger. The driver did admit that he had Parkinson's, and that justified his nervousness. The passenger was observed tapping the bulge in his pants with his finger. The officer goes back to his cruiser and then observes, it's not on the body cam necessarily, but observes him, moving his head left to right, lifting his body up and out of the seat. And the officer testified that in his training experience is consistent with concealing a weapon.
So
Notably,
let's assume for the moment that the officer could pull the defendant out of the car. And so when and let's assume for the moment he can do a pat frisk. I'm unclear why, when he knows it's money, why he can take it out of his pocket. Can he?
I think that it would have been best to, once he knows that it's money, to leave it inside the pocket. However,
Is there a consequence for him taking it out when he shouldn't have? Because, I mean,
Then I think we would go
with
to-
respect to my colleague, like a wad, you can't tell whether it's a wad of $1 bills, could have been 20 bucks. Turns out it was 1,240, but the officer shouldn't know that, right?
the officer should not know that, but he can tell at that point.
So
it's
what
a-
we know is that the defendant had money, which almost every adult has.
He described it as, and I'm paraphrasing, but a wad of cash in the pocket, and
Right, that's what young men do.
as well as drug dealers in this
Right.
trained detective's experience. So he knows now.
Right, but everything, this guy's got he's got his hands on, first of all, it is a little weird, but we'll take the finding of fact that the defendant is calm as can be when he's being taken out of the car and held for all that time. But let's just assume for the moment that he was somehow super nervous. But he's looking straight ahead with his hands visible on his thighs. But that is considered to be somehow suspicious. And let's go with that, even though at least one judge is rolling their eyes about it. But when you look at the video, can we see the corner of the bag that the detective says he saw?
I don't recall seeing you can see the, like the dirty seat, passenger seat.
Right, and I see what
items.
looks like the corner of an M&M bag, but,
He describes it as the knotted corner cut baggie. It's not clear in the video. The body camera, while the words and the conversation is very clear, the movements are not seen, and I did not observe the corner cut.
There's nothing in the video showing that that there actually is a baggie, or that he takes
Yes.
it, right? I mean, I think we can all agree on that.
Yes.
Right.
all right. I mean, looking at the video, it would be helpful if you think it's on the video, if you would let us know that. I see what could be a piece of lint, or I
No,
suppose
the
it could be
video,
the...
it's not very clear. You can hear the words and hear the conversation and the fact that everybody is very calm and it's very conversational car stop, but I couldn't see specifically the bag. You can see items and dust and dirt on the car seat, but
Okay, so once he's got him out of the car, he's frisked him, he's found some money, but he did not find any drugs. He then checks the passenger area where the guy was sitting. He lets go with it for a moment that he sees the corner of a plastic bag, but he doesn't find any weapon and he doesn't find any drugs on the guy or on the car.
correct.
What permits him to continue the detention at that point rather than give a ticket to the driver for having his expired inspection sticker?
So at that point, we know that the truck had left a home where the officer was aware that there was narcotics and
Can we consider that? Why can we?
Yeah.
The
The
judge
judge says
didn't-
in a footnote, right, that he doesn't.
He doesn't consider that, however, the entire record, I'm arguing that that's part of the entire record. The judge didn't consider that, however, that's what the officer observed, and that's what he knew. The car is on the side of the road, and he observes the passenger lifting his buttocks up out of the seat and moving his head left and right and sitting back down, and the nervousness of the passenger will leave the driver aside for a moment, exit the vehicle, sees that corner cut baggie. So now the trained narcotics investigator knows that One, there's money. Two, he saw a corner cut baggie. Three, that there's nervousness of this passenger. So he has him on the side of the road, handcuffed.
But now
which
the
is-
nervousness has gone away, because we can see that.
Yes.
I mean, do you contend he was nervous once he was out of the car?
Once he was out of the car, I didn't see any nervousness or anxiety or
Okay,
shaking.
and the officer has literally searched his body, and, you know, it turns out there were drugs, but the officer did not find them at that point, and he didn't find drugs or a weapon in the car. And we know the officer is not searching or not, okay, the officer takes a phone out of the side door, pocket door,
Yes.
right? And then he knows it's not a weapon because he's holding it in his hand, and he put it back down, but then he picks it back up again and he triggers it so that he can see the notifications. Was that a permissible search?
When you say he triggers it, I didn't see him touch or manipulate.
Oh, yeah, no, he manipulated
I
the
didn't
phone
see
so that
him.
he causes the screen to come on so he can read the notifications.
When you pick up a phone.
Nope, the first time he picked it up, no, oh, this was intentional. He picked up the phone, the screen did not trigger. He put it back down, he picked it back up again, he manipulated it, and the screen came on. I'm happy to have you watch the video later, but
I've watched
if-
the video
if-
numerous times. I didn't see him clicking buttons to get into the.
He didn't click a button, he touched the screen. So let's assume for the moment that he did that. Let's assume he triggered the phone so that so he could read the notifications. Would that be permissible?
Under Riley, in United States v. Riley, in the case law, no, you're not allowed to manipulate or touch a phone in a way to review what's on that phone. I agree with that. I do disagree with him manipulating it in the way that respectfully the court described. However, there's nothing in this record that he got any evidence or anything from that manipulation, if that's how the court wants to characterize it. It
Well, the
appeared to
video
me-
will speak for itself, but my question is, once he's searched the passenger area, he didn't find weapons or a drug. He's searched the defendant, he didn't find weapons or a drug. Why at that point can he continue the detention?
Well, then at that point, analyzing it, it's limited in duration. It's necessary to complete the inquiry as to who is this individual. He has, there's an issue with trying to figure out what his name is, and he runs his
Tells the officer what his name is.
and there's an issue with the last name as to if it's the correct last name. It
Well, it was
appears to be an
because
interpretation.
It sounded like Stewart, I think,
Yes.
right? That's what the officer put in, but the defendant was quite forthcoming, wasn't he?
was.
And he was cooperative, the judge found he was cooperative, the officer testified to that. So again, I follow up with Justice Henry's point, like how do we get to extend, how does the officer get to extend that detention? In fact, he arrests him, right? He says he doesn't arrest him, but he handcuffs him, and he specifically says, you're not under arrest, but I'm handcuffing you, right? And has him seated down there while he continues the.
In the Commonwealth's position, it's a reasonable, measured response to an ongoing developing situation where yes, he was nervous when he was seated in the car. Now, he's not nervous, but we do have that in the officer's experience, the corner cut baggie underneath where the defendant was seated.
But again, he did a search. He did a search of the passenger compartment, right, of the car. He searched, he pat frisked, and then he goes into the pockets, which you concede he shouldn't have been able to do, right, and finds the money. And at that point, what else?
Well, we know that, one, he does have a large amount of cash on him, and again, guiding the court back to the fact that the defendant had lifted and moved his body around. The officer did ask him, were you playing on your phone, were you using your phone? And he said no.
But he dispelled that he cleared there's no weapons. There's nothing that's found in the car, right?
Yes, and again, he's on the side of the road, and they're just asking him the reasonable measured response to this developing situation of what is your name, and they run his information in the police terminal. It's as the case is developed with these plus factors. It's a minimal encounter. I think the judge found that it was 15 minutes from the exit to the point where he was given Miranda rights. As the facts are developing where nervousness, and yes, he did stop being nervous when he was exiting the truck for whatever reason, but we still have that nervousness at that point.
I want to focus on the not being nervous when he got out of the truck. So assume we agree with you that there was a reasonable safety concern that justified the exit order, but to justify the subsequent pat frisk, officer needs reasonable suspicion that the defendant is both armed and dangerous. What evidence is there that a reasonable suspicion that he was dangerous?
At the point of the search of his
At the point of right before the pat frisk, because that's at the point at which the officer needs to know whether, he needs reasonable suspicion that the defendant is armed and dangerous in order to do that pat frisk.
Yes, so the observation of him moving around in the car and the nervousness of both the driver and the passenger and the trained investigator's experience of that he believed in his position that he could have been reaching for a weapon.
So nothing more than, it's the same facts that justify the exit order to justify the pat frisk? There's
Yes.
nothing more that happened.
He also asked him
After-
about his cell phone. He said, were you using your phone? And to give him a question as to why was he lifting and moving his body, and the defendant said no when he had it in his hand. So I think at that point,
He said, were you playing with your
were
phone?
were you using your phone? And he said no, so.
He said, were you playing with your phone?
Right.
And the defendant seemed to be trying to say something that the officer wasn't interested in hearing. But what is it that gives the officer reasonable suspicion that this defendant is dangerous?
Because of the movements, because of his experience as an officer where he observed him lifting his buttocks again out of the seat. And I would guide the court to the case that I cited.
Well, that might create a reasonable suspicion that he's armed, but those are two separate things, armed and dangerous. So even if we agree with you that there was reasonable suspicion the defendant was armed, what is there that gives the reasonable suspicion that he was dangerous?
His consistent behavior of his nervousness, tapping his pocket. At that point, we didn't know what was in that bulge in his pants.
Well,
And
you've said that when he got out of the truck, he wasn't nervous anymore.
after the pat frisk, he all of a sudden is
Only after the pat frisk that
extremely
he's not
calm, and he changes his demeanor. And it's very conversational, very calm on both sides, from the detective to the defendant. I would describe it as a very conversational car stop. And he dispelled any nervousness after that pat frisk. And then they turned to searching the limited area of the car, which the detective is permitted to do, to determine if putting him back in the vehicle, if there's going to be a weapon or something that he could reach for, based on, again, his movements of his body, turning his head and lifting himself out of the seat.
So in Alvarado, the SJC concluded that the police officer had probable cause before he searched the defendant. At the point where the officer has pat frisked this defendant, not found any weapons or drugs, searched the passenger area of the car, saw the corner of the bag, but doesn't find any weapons or any drugs. The defendant was nervous, now he's not nervous. Did the detective have probable cause to arrest at that moment?
No.
Okay. So he had, I guess I'm still trying to, can anything ever be dispelled? Was anything, in the Commonwealth's opinion, was anything dispelled at this point? He's not found drugs anywhere. He hasn't found a weapon anywhere. The defendant is no longer nervous.
At that point, when he was asking him his identity, and there's confusion of Steward versus Stewart, and the officer goes back to the terminal, runs the information, and finds that there's open drug cases for distribution, closed drug cases. At that point, it's the Commonwealth's position that now we have indication for further inquiry. I think that is that plus factor, determining his identity and getting to his prior criminal record, and the fact that there are open cases for distribution. Now that corner-cut knotted baggie on the seat.
Right, but that's what I'm asking. Why could he go back and run that record? Why did the searches, finding nothing, not dispel the reasonable suspicion?
Well, I would disagree that finding nothing. We have cash in his pocket, which, yes, everybody has cash in their pocket except for me at this moment. And the corner-cut knotted baggie on the seat, it required further investigation.
Well, hold on. I mean, first of all, was it a knotted? If it was a knotted baggie, it was going to have drugs in it, and he did not take that. So I thought all that there was a corner.
It was the knotted part of the baggie. There were no drugs. I completely agree. That's
Well,
what
then how can we even, if it's a knotted corner with no drugs, I mean, if it's, how does it, it's either
the
a corner
indicia-
or it's,
It's the indicia of distribution, along with the fact that he had a large amount of cash, nervous, and was moving, and that baggie was found where he was seated, where he was lifting himself out of the seat. So I think all of those factors added together
We don't know if
established.
it was knotted, do we?
He described it as the corner knotted part of the baggie.
Did he say knotted? Yeah.
Which in his
One corner, that could equally be consistent with use as distribution.
It could very well be, but even then, still, we have the same indicia of possession of narcotics, which he's permitted to investigate in his training and
He
experience.
didn't seize it. If it had drugs in it and they were used, then there would be residue, but he didn't seize it.
Right, he didn't seize it because he described it as the knotted portion of the baggie. And that's why he continued to investigate, to pat frisk the defendant. There's a large amount of cash on him, so we have the numerous factors of somebody who is in the drug dealing business, so to speak. If there are no further questions, I rest on my brief.
I just would like to hear from the Commonwealth, it can be a post-argument letter, whether the knotted whatever is visible in the video.
No, I agree, it's not visible. It's, you can see like dirt and debris on the seat.
Well, the car is
Right.
trash
Right,
strewn, right?
Yes.
Okay.
thank you.
Again, thank you very much. That was very well argued. We understand your positions, and the case is submitted. Our third case this morning is 2024 P641, Commonwealth versus JASZEK, or JASZEK.
Good morning, Your Honors. My name is Attorney Carl Suchecki, and I represent Stephen JASZEK in this matter. So Mr. JASZEK just did not get a fair trial. He was facing very serious charges, and the first thing he faced was an overwhelming amount of bad act evidence that was allowed into evidence. And going through the amount of bad evidence and
So first, could we just pause at the standard of review, because the Commonwealth says this propensity argument was not preserved in the standard as a substantial risk of a miscarriage of justice. What do you say to that?
I would agree that it's a substantial risk of miscarriage of justice, and with the amount of bad act evidence in that meets that high criteria.
Can we pause for a moment on the bad act evidence? The bad act evidence seems to be that he was a yeller and that he broke pencils or,
Threw furniture,
things.
intimidated students.
Right, but none of it was sexual, was it?
No, and that's exactly the point. And what happened in this, the amount of testimony, the amount of bad act quotes, shall we say, there are 8 different witnesses who spoke about Mr. JASZEK's bad acts, and his bad acts were violent. The bad acts were intimidating children. His bad acts were screaming at children, yelling at children.
Isn't that probative, though, of the issue of why the victim waited and didn't disclose at the time?
I think that
Because she was scared and
if
felt
there was one witness, if the complainant said it, maybe possibly 2, but if you have 8 different witnesses come forward and testify in extreme detail about how he was mad and loud, and he would throw furniture, and he would get angry and loud and verbal in the class. He said he broke pencils, he threw chairs.
Right, but also, is this a bench trial too, right?
Yes.
And so isn't there a body of case law that says that recognizes that judges, hearing a jury waive trial are better able to filter through and not be swayed by potentially?
Well, Your Honor, I'm going to go out on a limb and say that trial judges are people. They're human. And they're any kind of, I don't know about appeal court judges, but trial judges are human. And when you're faced with a large amount of evidence, negative evidence, that it doesn't matter who you are, if you're overwhelmed, you read through this, it feels, you can see it, you can hear it.
You just said overwhelm. Is your point that this bad act evidence was inadmissible at all, or just that the amount of it was excessive?
The excessive amount, They had 8 different witnesses testify to it. You had mothers, you had daughters, you had former students, you had principals, who when the principal got on, the only thing she testified was that he was loud and she had to interrupt his class, and kids were intimidated by him. That kind of evidence is not allowed in that amount. And a judge isn't immune to that. And not only are judges, trial judges human, ADAs are human. And so when faced with a jury waived trial, what you have here is a district attorney who realizes that he can say and do essentially anything because the judge will know and he can put as much as propensity evidence in because the judge is going to just know the difference. He can say whatever he wants in closing argument because the judge will know the difference. But that's not a fair trial. Mr. JASZEK didn't get a fair trial. This stuff shouldn't have come in this amount of. It's not about his temper. It's not about how he treated students. He was a 30-year teacher who had one person report.
Is a judge likely to be influenced by the amount of testimony about the defendant's bad temper into giving more credibility to the victim's testimony, which is really the key issue here?
I would think yes, Your Honor. And I think that a small amount of
the defendant himself, as I understand it, there was a transcript of the interview with him that's not in the record appendix, but that the defendant admitted to law enforcement that he had a bad temper. He wasn't contesting that.
Right.
So,
and I'm not contesting that in a small amount. It's one thing. Right. But if you're overwhelmed,
so why would that? I mean, I can understand why it might distract the judge, but why would it make him more likely to believe the victim?
Because it makes him into a bad guy, and it's not just him, but there's overwhelming amount of people who come in and say, the principal comes in, teachers come in, he's a temper, and if he's a bad guy, and he's human. I mean, that's the thing here. The ADA knows he can say anything. He can put anything on, and the judge is going to filter it out. But you get it out there, you're still affected by it. It's like any kind of propaganda, any kind of overwhelming amount of taint. It's going to infect the trial. And because of that, Mr. JASZEK didn't get a fair shake on just the propensity amount. This quote after quote after quote. Read through the brief. They're all in bold. You'll see he threw chairs. Breaking pencils was a big thing. So this was huge. And in this case, because the ADA knew that he could put anything on, and the judge is supposed to be able to filter it, he can say that. And the worst, of course, was the closing argument, Your Honors. And if you read through that closing argument, there's no way this would pass muster in a jury trial. But because he's a judge, the prosecutor thinks, oh, I can say anything. And he calls Mr. JASZEK a predator not once, but twice. You're not allowed to say that. You can't name call. You can't call the defendant names.
Well, it was interesting that in the defense counsel's opening, he says, practically the first words out of his mouth is, well, the Commonwealth was going to get up and try to portray my client as a predator. Mm-hmm. So he knew that was coming, yet he still didn't object when the Commonwealth said it. What do we make of that? Aren't we supposed to give some attention to, well, experienced defense counsel? I definitely would prefer more objections than less objections, especially in closing arguments. Here, I believe there should have been an objection, and especially even a layperson reading through this closing argument can see the amount of I'll go through it for you. The personal opinion, when he opens, he says it defies common sense. It makes no sense that the complainant could make those things up. And he says the only way those... You say you wish there had been an objection to the predator statement. What would that look like in practice? Does the defense counsel just approach, well, he doesn't need to approach, there's no jury, just say after the Commonwealth sits down, Judge, I object to the use of the word predator?
He could do it after the closing, or he could do it during the closing, and I've seen it both ways.
What effect do we think that would have? I mean, I know sometimes we say, well, objecting just would have increased the attention given to the issue. Could it be a reasonable decision not to object?
No, I mean, because we're now
trial. We're at a bench.
Yeah, right. We're all under the presumption that the judge knows better and he can filter this out. And I think there's probably a lack. The defense counsel probably a little more lax in terms of objection because of the same thing. This guise of this judge being all-knowing and being able to filter all out is, I think, kind of a ruse, especially when you see this kind of closing, when the prosecutor knows there's no recourse. There's no, what's the consequence? He knows he's not, the judge is going to filter it out, so he can call him a predator, it doesn't matter. He can say practically anything, he actually does. He says, the reason the complainant is saying this about a man that she didn't see in almost a decade was because he did it. That's his opinion.
So let's say he objects. What does the judge do then? Say, I'm going to instruct myself not to pay attention to the use of the word predator?
It is a convoluted circle.
Well, does that do any
gets
good?
that. Right, so but if, in isolation, okay, if you're taking one or two quotes, that's one thing. But if you look at this closing, and you look at the amount of bad act propensity evidence that came in, Mr. JASZEK didn't get a fair trial. This closing argument is like, you could put it as a textbook of what not to do. I mean, he's calling him a predator. He's using his own opinion and saying, oh, he did it. He says, because he did it, they tell him it makes no sense unless it actually happened. I mean, when he appealing to his sympathies, he says, when he says he's a predator, he's just too deep. This is a quote. The combination of brilliance and deviancy, he says. There's nothing about the client that shows that she is even capable in the deepest recesses of her mind of coming up with something like that. No one is, except for a predator who spent 30 years around elementary age students, who has watched them, who has understood them. That is the only type of person who could come up with something like that.
So if the judge had said, if there'd been an objection and the judge had said, I'm going to instruct myself to ignore the use of the word predator.
Correct.
And everything else you objected to, Mr. Defense Counsel, then what?
I would still be up here arguing that he shouldn't have said predator and that it infected the trial.
And that the trial judge's instructions to himself weren't sufficient to cure the prejudice?
See, this is the circle we're caught in, because a judge can't be all hats. He's got the hat on as a jurist. He's got the hat on as a jury.
And do we have to, so your point is that sometimes the rhetoric and the ridicule and the disparagement is just so much that even if the judge says, I need to put that out of my mind, the judge can't do that.
Exactly.
And
I
think
don't think
that's this case?
I think, yeah, you know, I think if you look at this closing argument, I don't think you can filter it out and pretend. And at some point, the DA's got to realize, or that you can't do this. There's no reason this should have come in on any level. And the amount of taint for his personal opinion, you can't do that.
Could the Commonwealth have
insulting,
said,
he can't do that. I'm sorry?
Could the Commonwealth have said, you know, the victim testified that the defendant told her she raped him, and that what kid in the 3rd through 5th grade could come up with that? Is that a proper argument?
If taken in isolation, I'd have to see how it works out, because you know, I have to play it out with the law and how it's written out. That in isolation, if that was the only offense in the closing argument, I would think that would probably get passed through. But when you're going through his opinions, he tells you what his opinion is. Calling Mr. JASZEK a predator, not once, but twice. Then he goes after the defense counsel. He makes a big hay all the way through, even in his closing, that records that she had no business going through. He says that the defense counsel pawed through all these records. He said the personal and intimate information is now available to a defendant to pour through and manipulate and attempt to discredit the victim. That's his job. He's looking for...
I agree that that's his job. The only part I found objectionable in that, at least at this point, is the part where he says, and whatever other nonsense counsel wants to talk about.
Exactly.
Okay, but what else in there was disparaging?
Well,
he's just saying, well, the defendant is going through plucking things out of context, trying to convince you not to believe the victim. What's wrong with that?
The way he phrased it, and it's throughout his closing argument, it's to appeal to the sympathy. This poor victim had all her records pulled. He went through and he pulled quotes. He knows that that's the defense counsel's job. He knows it's his right to go through those medical records. He knows that's his right, but he's using it to create sympathy, that this poor woman had her medical records pawed through because he's looking for a defense, which is right, which is everybody's right in this country. And then he says he's attempting to weaponize those clinical terms. It's not weapon. He's presenting a defense for his client.
Is that so bad? I mean, hasn't the term weaponized become so common as to be almost meaningless? I mean, it's not really that disparaging anymore, is it?
I think in isolation, if we parse each particular quote that he says, and if you take that one and say that's the error in closing argument, okay, that's not so bad. But we're looking at
So you've got 2 weaponizers, 2 predators, and 1 nonsense.
In addition,
endures.
And a lot of, the enduring is above and beyond. That's the biggest appeal to sympathy you could actually see. I don't know if you, this is, he literally says this and for no other reason than to create sympathy for this complainant and saying that she's a victim because she went through this. The complainant has endured. She has endured unspeakable acts of depravity again, at the hands of the defendant. Her teacher that was in a position of trust. She has endured some of the most deviant mental manipulation that anybody could possibly think of. She has endured through years of keeping a terrible secret.
I think that the phrase deviant mental manipulation was supported by the evidence? I say to the child, you just raped me, but I'm going to forgive you.
Your Honor, you can call it what you will, but you're not allowed to call names. You're not allowed to disparage the defendant in such a way. And the fact is the way this process...
I'm asking you if it is unfair disparagement. I mean, you can say bad things about the defendant if they're supported by the evidence.
I'm not going to qualify that. I can't say that that's appropriate or inappropriate. I do think that it should not be said in closing argument. It shouldn't be said in the courtroom. He's not allowed to say it's an act of depravity. He's allowed to present the evidence, fair inferences therefrom, and concoct an argument that doesn't rely on sympathy or hyperbole or emotion. And judges are human, even appeals court judges. And the fact is they are swayed by the amount of content that comes their way. And if it's overwhelming amount of bad act evidence or a closing argument that's rife with abuses, he needs a new trial. He did not get a fair trial. He did not get a fair shake with this amount of evidence. The way the judge dealt with it, it should not have come in. And Mr. JASZEK deserves a new trial in this matter. So, thank you, Your Honors.
Thank you.
Good morning. May it please the court. Donna Marie Heron, Assistant District Attorney representing the Commonwealth. Judge Ritter here in a jury-waived trial properly admitted evidence of the defendant's anger and explosive outbursts as it was highly probative of the defendant's state of mind, his opportunity to repeatedly rape the victim, and the reason why the victim didn't immediately disclose the assaults and continued to endure.
The defense counsel has agreed that the evidence was admissible about his bad temper and breaking pencils. His argument is that there was just too much of it. What do you say to that?
The defense made his defense clear in his opening and closing that this was a troubled girl that had false memories that was making all this up. So I think the Commonwealth is entitled to present pieces of evidence that corroborate, amongst other things, the victim's testimony and having all these...
Temper.
His temper and that.
Yes,
and
the
about
Commonwealth, just to clear the underbrush, the Commonwealth did a very good job in its closing of saying all the different things that different witnesses corroborated, details that the victim remembered, and one of those was the defendant's bad temper. But there were at least 6 witnesses who testified about bad temper. 1 or 2, sure. Why 6? Particularly when the defendant had apparently admitted it already in his interview with law enforcement, so it wasn't a contested point on which the Commonwealth really needed any corroboration. Sure, you can put in a little bit, but doesn't it get excessive? Doesn't it risk painting the defendant as just a bad guy who should be convicted?
I don't think that's what it was used for. I think it was used to show how he isolated the victim, how he groomed her, how he...
Why did you need 6 witnesses to do it, plus the defendant's own statement?
Well, if this court finds that is excessive, this is a jury-waived trial, and the judge is presumed to accurately instruct himself on the law and to not consider erroneous admitted or abusive, or if you think it's too much, I think Judge Ritter is presumed to not be persuaded by that.
I do think trial judges are human. I think we're human. And I think there's an argument to be had, certainly, that we see so many rape cases that we might even get a little desensitized to some of these facts, so maybe all of this didn't bother the judge. But when we say the judge is presumed to properly instruct himself, wouldn't it be better if the judge indicated he was instructing himself properly by saying, counsel, enough? Like, in other words, when he keeps letting this all in...
Without objection, Your Honor.
Right, I know, but at some point, shouldn't the judge say, okay, we're at 4 witnesses, 5 witnesses, 6 witnesses, got your point?
Well, I disagree. I know the court might disagree with me. I don't think it was, I think it was properly admitted, and I think Judge Ritter properly admitted it and thought it was probative, again, of the defendant's state of mind, of of why the victim didn't testify. And judges every day are
I'm
told
sorry,
things.
why the victim didn't testify?
No, I'm sorry, why the victim didn't disclose. I didn't mean to
Disclose.
say
Okay, thank you,
testify. I
sorry.
apologize for that, why the victim didn't disclose. And I do want to say one thing that was said here and was said below, and in closing argument by the defense counsel and at trial. While this victim was the only one to testify against the defendant, she was not the only one to report against the defendant, and that was during cross-examination of the detective that was made clear. And
Was that admissible?
the defense elicited that. He said she's the only one in 30 years, which was made similar here, to disclose. And he goes, that's not true. There were others that disclosed. The prosecutor then asked to be seen at sidebar and said to the judge, there is evidence of him abusing other kids, but I'm not going to bring it up. But I think the defense has opened the door by suggesting she's the only one in 30 years of his tenure as a music teacher to ever disclose.
Let's see how that relates to whether there was excessive bad act evidence.
I'm using that to show you that in bench trials, there's motions in limine. There's a lot of times a judge learns stuff that they're not supposed to know. In this court, and the courts presume that they will exclude or not consider that because they're not supposed to. I disagree that the amount, I think it was proper. I think Judge Ritter properly admitted it. But even if this court, I think, were to conclude that there was too many witnesses to testify, which I don't even know this is bad acts because it's just anger and explosive behavior. But even if this court says it is, I think the law is clear that Judge Ritter is presumed to not be so swayed by this, to not be.
Presumed, but do you agree there might be a case, not necessarily this one, in which the amount of inadmissible or excessive prejudicial evidence has an impact on the judge that the judge might not even realize at the time?
There could be a case. I couldn't even find a case similar to this where this was qualified as bad acts. I really tried hard to find one, and it's usually a prior crime or similar thing, similar like sexual assault.
Evidence of bad temper in domestic violence cases has bad act evidence all the time, so I don't see why it should be
I
different
found
here.
it was prior abuse. I actually could not find one where, but
Assuming it is, and
assuming it is, I think that, not in this case. I think it was properly admitted.
how do we tell when that case is? Should the defendant move for a new trial, saying, Judge, you might not have realized it at the time?
I think the
but
defendant should object at trial if he thinks it's so overwhelmingly prejudicial. This was all admitted without any objection. If it was so bad, why did defense counsel not object? I think he knew it had probative value that.
Do you think there's anything to the notion that that would just call more attention to it, or is that really only the case with jury trials?
I think it's only with juries, because the juries aren't sophisticated. And I do want to, with the closing, with predator, the courts, and it's I cited it, it's the Ormond case. A prosecutor is entitled to use the word predator, which was only used twice by the prosecutor and was used by defense counsel, if such accusation is supported by the evidence and relevant to the Commonwealth's theory. The Commonwealth's theory here is this music teacher used his position as a music teacher to repeatedly rape the victim. Not only did he then call her a rapist, he told her that her mom was dying of cancer, and if she were to disclose the rape to her, she would die sad. So I think
That's devious, that's horrible, but is the word predator really apropos? Doesn't predator involve or imply someone who has a number of victims?
Oh, the manner of which I think it was proper here, the manner in which he isolated the victim, kept her in by herself. He was a predator. I think it was a proper use of the term. But again, even if this court were to conclude that it was not proper, the judge is presumed to instruct himself to not consider any improper argument. And I did cite the case. I could not find any case in a bench trial where closing argument was not objected to, was reversible, but I did find one where the court found it was wrong. It was the Daly case where the prosecutor misstated the evidence on various points, and this court affirmed, saying that the court is not concerned with the effect of the misstatements on the jury because we presume the judge would distinguish argument which is permissible and argument which is not.
Daly?
Daly. It was misstating of the evidence, but the court there, even though the court found that the Commonwealth did misstate the evidence, said because they don't have the same concerns as they do with the jury.
So, and I have to say, I actually found the defendant's brief very helpful in putting in all the quotes and the bolding. That really, because we do just get an overwhelming amount of information. So I found that very helpful. But I see your point about predator, but I was more troubled about the disparagement of defense counsel. Do you really think that didn't cross, even if we affirmed, did that cross a line? I mean, that he was doing his job.
He was commenting on what he was doing, which was taking, I think it was inaccurate, because as the
He could
case
say
law shows.
he could say he was taking it out of context, but he said far more than that, didn't he?
I think the point of his closing with that was that the defense counsel was taking one or two phrases or sentences out of the victim's mental health records and distorting it and misusing and doing that. He does, I will admit, with that in the endure, this prosecutor came, quote, cast in one case, dangerously close to the third rail. But given this is a bench trial and the judge is presumed, I don't think it's, and there's no objection, I don't think it rises to a substantial risk of a miscarriage of justice. Was this the model of closing arguments? No, I would concede that it was not. But given the evidence that was presented and the fact that this was a bench trial, I would ask this court to.
Right, but I mean, I'm looking at page 47 of his brief, but because he says, you know, this personal and intimate information is now available to the defendant. Well, yeah, I mean, that's not improper, right? I mean, it's uncomfortable and it's probably very upsetting to the victim.
And had this been a jury trial, we could see how that could be very problematic. But given that Judge Ritter is the one that's allowing it into evidence, he's actually, in a way, cutting his nose to spite his face because he's now insulting Judge Ritter, saying, you allowed all this evidence in.
So how do we convey to ADAs, trial ADAs, that they shouldn't do this stuff?
Even in front of a judge.
Yeah, even with a bench trial, and God forbid they should do it with a jury.
Do you concede that this would be problematic?
I think it'd be
if
a
it was-
whole different analysis and problematic if this was a jury trial. I do concede that. It would be a whole different analysis, and I would have I would be a very different argument I'd be making up here. But given that this was a jury waive trial and the judge is presumed to ignore improper argument and to rely on the evidence, there's no objection, there's no substantial risk of a miscarriage of justice. If you want to lambaste the prosecutor in your opinion but still affirm the conviction, that's how you can send a message, I guess, if that's what you're wanting to do.
So that's the piece, though, that bothers me, and apparently it bothers my colleagues. Like Chief Justice Hennessy 50 years ago, at this point it might have been 60 years ago, wrote that we have a problem with closings, with Commonwealth closings, literally 50 to 60 years ago. And so I really do genuinely appreciate your conceding this is not a model or whatever, you know, generalized vague language. That's fine. I appreciate it. But we keep saying it, and then decades are going by, and it keeps happening. So at the very least, is there the next piece, which is that this isn't how we train people, or I will talk to the prosecutor, or is it just we need to lambaste them? But then that doesn't seem to be working.
I know this, I want to take this case apart because I will concede this isn't the best closing argument I've ever seen, and I'll be blunt with the court. I have already talked to the prosecutor about this case, if that helps you. And I personally give closing argument trainings where I use where things can go wrong and when things can really go wrong. And our office does do that. So I can, if that helps alleviate any of your concerns, that does occur in at least my office. I can tell you, I'm personally the person that gives the closing argument trainings where I use cases as examples. For instance, I remember there was the one by the SJC where the prosecutor said, I went to the crime scene, I saw, and I believe he was reported up too. So I just said, that's my example of things can go really wrong for you when you got to be careful of what you do.
It's curious why the prosecutor would feel the need to engage in this arguably improper argument when the judge is presumed to disregard it. I mean, what is he practicing for how close he can sail to the wind in a jury trial?
I think he's a very passionate prosecutor that may have let his passions get the better of him during his closing argument, given the severity of what had occurred in the evidence that was presented. If there's no further questions, the Commonwealth will rest on its brief.
Thank you very much. Again, we've had a very good morning in terms of quality of argument. We're going to take our mid-morning break, and we'll be back out in approximately 15 minutes.
All rise, please. All rise, please.
Welcome again. We're here for our fourth case, 2024 P1186. I'm not sure everyone was here at the beginning of the morning session, so I'll just say again, we have 15 minutes per side, for better or for worse, no rebuttal. And I can assure you that we are familiar with your materials, so I'd encourage you to get to the heart of the matter, but proceed as you see fit. This is Jeffrey King and another versus Harwich Conservation Commission et al.
Good morning, Your Honor. Paul Revere on behalf of Jeffrey King and his husband, James Kelly. Get them both in the record here. This is a case, I say, this is what's wrong with land use law in Massachusetts. It's a wetlands case, but here, Mr. King and Mr. Kelly bought an existing developed property. It had a main home and had a one-bedroom cottage. They built two small additions onto the one-bedroom cottage, a 10 by 12-foot area on the cottage, which is actually has the cottage between it and the wetland, and they built a deck on it. Both of them were built in an already developed area, in the grass, sitting there. They ended up in what you actually now have two cases before you. One is an enforcement order brought by the town, or Conservation Commission of Harwich, which was appealed.
So by the grass, you mean like a developed lawn?
A developed lawn. In fact, it's funny, I circled this and put stars next to it. You really get some of the point. If you look at volume 2, pages 24 to 27, it shows photographs of the area, okay? Mind you, the building is not upside down. Page 24, the photograph is completely upside down. But you see it's a developed lawn. It has this area that looks like a forest next to it, which technically is legally a wetland.
But I think it's not disputed that there was construction done within the 50-foot no disturb zone. You might not like the no disturb zone. We might not like it, but it's lawfully adopted. You're not challenging its validity. So,
actually, there is a little challenge in here to its validity.
oh, because it's not, you think it's zoning?
Well, yeah. Let me.
Hello?
Yeah. Let me explain this very simply.
Was that raised? Well, I think we know what the argument is, that it's a zoning bylaw and it wasn't passed pursuant to the 48 procedures.
Correct.
Was that raised to the before the Conservation Commission?
It was not raised before it was raised before the Superior Court. Okay, the Conservation Commission isn't going to decide issues of law.
In the second case, it was raised.
It was raised in the second case.
Was it raised in the first case?
In the first case, it was not raised. There were other issues. But the real point that's important to this is that the Harwich Conservation Commission issued a permit under the Wetlands Protection Act. They said there's no impact on the wetland from this construction. They issued that permit. But they said, we have this no disturb zone, and you didn't get a permit under the no disturb zone. Well, I laugh. In my mind yesterday, I was going, it's the no build zone. It isn't the no build zone. It's the no disturb zone. And guess what? It's already a disturbed area. We didn't, as stated.
But no disturb means don't, whatever happened before, we can't undo that. The prior owners, maybe your clients aren't responsible for that, but that doesn't mean that they can disturb it further, does it?
Well, they certainly could maintain that lawn forever, fertilize it, continue to.
But let's focus on the building. Didn't the building constitute a disturbance?
Right. I'm not disagreeing that it constituted a disturbance from existing conditions, but it's not a no disturb zone when you took, for want of a better term, virgin property. Don't like that as a proper term, but I can't come up with a better one off the top of my head. Wilderness that had never been changed and then made it into a developed piece of property. No, you're talking about a piece of developed land. And my argument is if it's not impacting the wetland, then there are two types of wetland ordinances and bylaws in Massachusetts. One are zoning based, and then there is, which was upheld in Lovequist, you can have essentially an environmental base. When you're having a setback from a wetland, not to protect the wetland, then you're really no different than a zoning setback. And again, as you pointed out, JASZEK, you need to follow zoning procedures to do that. Town meeting vote, 2/3, planning board review beforehand, et cetera. But so that is that argument, is a challenge to that issue. I think one of the things, too, we have 2 points here. I'd like to address first briefly the enforcement order. The enforcement order, there's a Doobie case, which came down as some of this was going on, and says, look, if you build something in the buffer zone, okay, and you don't apply for a permit beforehand, and there's no allegation that you disturbed the wetland, then the relief is not you must remove what's there. The relief is you must apply for a permit. And the Conservation Commission, rather than saying it's a single violation, you acted without applying for a permit, they said, you can't get a permit, tear the place down, okay? And Doobie says that's a one-time violation. And we get this other dichotomy that's kind of important here, is when you look at the enforcement order, it was issued under the authority of the bylaw and under the authority of the Wetlands Protection.
Doobie was under the Wetlands Protection Act? Doobie was under the Wetlands Protection Act?
Correct.
Not under the local bylaw?
Just, off the top of my head, I don't remember whether they addressed a Bridgewater bylaw in it. And I say, off the top of my head, I could answer that in a few seconds. I'm sure your law clerk could too. But the point I was getting to is that my client then applied for the after-the-fact permit, obtained the permit under the Wetlands Protection Act, and I would say to a large extent, the enforcement order, except for the single violation that you didn't act without applying, is moot as to the Wetlands Protection Act. So then we're left to the bylaw. And one of the arguments I make in the bylaw is, does the Conservation Commission, well, while we appealed the enforcement order, the Conservation Commission made counterclaims. And the bylaw in itself says that the commission can ask the town or ask the selectmen to enforce an order. The Conservation Commission itself can't go to court on its own.
And so the counterclaims on the complaint and counterclaim at Record Appendix 127 are asserted in the name of the defendant, Town of Harwich Conservation Commission.
Yeah, and that's
Okay.
it.
So is that different from the town?
Yes. Oh, my God.
Well, what if there were a comma after Harwich? So it Town of Harwich, comma, Conservation Commission hereby answers and asserts the following counterclaim.
I think they'd have to be a third party, but I
mean, the Conservation Commission is an entity formed by the town.
Yeah, well, I was getting this point.
It's not a separate body politic or corporate. It doesn't have any separate corporate existence. If some, if some conservation agent gets in a car accident, it's the town that's going to pay under the Tort Claims Act. What's the difference between the Conservation Commission
Okay,
and the
so
town?
the reason I'm smiling is this is Cape Cod, okay? North of Route 6 from Sandwich there's a little part of Orleans that actually is north of Route 6. There's something called the Old Kings Highway Act. And there's a famous case, Attorney General v. Barnstable Old Kings Highway. And it addresses the issue of whether the Old Kings Highway Committee of the town of Barnstable could take an action in terms of litigation. And what the ultimate outcome of that case is that the executive officer of the town, the selectmen, are the people who can only act to do litigation. A board can't do something on their own. And there are similar cases, and I've got them, they're cited in my brief.
They've got town council representing them. Are we supposed to presume that they don't have proper authority,
well,
despite the presence of town council?
The bylaw that was passed by, I love to call it the legislative branch of the town, which is town meeting, said the commission can ask the selectmen to enforce the bylaw, okay?
Because it's the selectmen that can make the decision whether to pay town council to do something.
No, but they can bring the action in the name of the town, okay? So
you contend that they had no authority to, did they have the authority to appear and defend against the claim?
I think they have the authority to do that. And conservation commissions are, they're actually, the town has to adopt a statute to create a conservation commission. And the conservation commission, as one of the appeals court decision talks about, in certain parts of their hearing, they wear the Wetlands Protection Act hat, and then they take it off and they put on the local bylaw hat. So they have an independent creation by statute. The statute has to be adopted, but they do certain state activities and they do certain local activities, and they control certain properties based on statutes. I want to get over to the second half of the appeal, because there are two cases here, and the clock is running. That is, we have the issue of the after-the-fact permitting. Clients, they went in, they attempted to file for an after-the-fact permit. This is a classic way to resolve narrow issues, deal with things. As I mentioned previously, the after-the-fact permit was issued under the Wetlands Protection Act. It was only this no disturb zone issue that was sitting there. But Harwich, it's quite entertaining, has the famous case called the Oyster Creek Preservation case. And there's a further continuation of that concept of that case called Boston Clear Water. And what it says is, look, if someone applies for a Wetlands Protection Act permit and you don't act within the statutory timeframes, you don't open the hearing within 21 days, that's Boston Clear Water, or you don't act within 21 days after.
Is this your argument about the agreement to defer the hearing or being involuntary?
Yes, the waiver issue. In fact, in the waiver issue, my client's
The commission has a waiver letter signed by the plaintiff's representative. That certainly seems to meet its burden of coming forward. What's your evidence that that was involuntary?
Well, the evidence, I think, is that it was required to be submitted, which is the same problem of the Garrity case. The only difference is the Garrity case.
How was it required to be submitted? What's the evidence of that?
But it was based, if you look at...
It's not on the form like in Garrity, where that's one of the boxes you have to check.
You got it right on. I was going to say, it was on a list in Garrity. That is the main difference in this case. No, what the person came in and said, we can't hear you within 21 days. You need to sign this. And it was accepted as being signed. There's various emails which are part of the record. I had to re-look at this between Ms. Quessel and the conservation administrator to make sure we didn't somehow slip in. Yeah, I didn't slip in somehow an attorney-client conversation. No, that was clearly in the record before the matter, that they would only take it if they gave the 21-day waiver.
But again, what's the evidence that this is involuntary?
That's what I'm saying. The evidence is, if you look in there, there's emails back and forth where Ms. Usowski says, well, we weren't going to let anybody take it in unless they signed the waiver at that time.
I want to make sure I understand this. So you're saying that they wouldn't even let them file unless they gave the 21-day waiver, and that was not permissible?
Correct. That's the essence. There's also the issue of you open up a hearing, they then continued it even farther without a further approval of my client that is in there. There are a couple other issues, and this kind of brings this up too, which it's actually one of my favorite cases. In the enforcement order, the issue is who has the burden of proof. In enforcement, the famous, I call it the Hilda Austin case, but it's Bourne v. Austin that says, if you want to enforce something, you carry the burden, town of Harwich. It's not like a classic certiorari case, and Alpha Epsilon, we're back to Bridgewater. It was actually Bridgewater State University, was that matter. If you're going to have enforcement, no matter how you get there, the burden of proof is on the Conservation Commission. So they carry the burden in the enforcement.
What didn't they prove? What didn't the commission prove? Do you contend there's no evidence it was a salt marsh?
There is no evidence that it's a salt marsh at all. That's in the record.
Okay, well, actually, I wanted to ask you about that. Record Appendix 3, page 105, is a revised plan that your clients submitted on June 20th of 17 to add a coastal wetland flag that says salt marsh flag on it. So your client submitted something to the commission that says salt marsh.
And what is that in the record appendix?
Record Appendix 3, page 105.
3, page 105. And is that 9 feet off the side of the building? Because there is a salt marsh out there.
No, the flag isn't 9 feet off the side of the building, but the flag is out in the marsh, and
Right.
it appears to be a continuous
Okay.
marsh all around this sort of peninsula.
No, actually, it's kind of interesting here. The salt marsh is about 41 feet away from the area of the house. In time, wetland flagging has changed. May I finish my answer?
Yes.
Okay. Wetland flagging has changed from when the original building was built or cottage in 1985, such that you delineate wetlands by looking at what are called facultative species, et cetera. And therefore, the wetland line came closer. That's just a bordering wetland. It's not a salt marsh. A salt marsh is defined, and you see it in my argument, as an area by the highest spring tide. It's kind of interesting. I watched the news this morning. They were talking, now the word is king tide, but it's the annual high tide from the moon that may be keeping you up at night if you have a window that faces to the south like mine. But that's what defines the salt marsh, and there's no evidence that we were 9 feet off the salt marsh. We were way away from the salt marsh. We might have been near this newer wetland. Thank you.
And the buffer zone, just so we're clear, the no disturb zone is measured from the edge of the wetland, whether it's a coastal wetland salt marsh or whether it's, I don't know what EW stands for, but it's some kind of wetland.
A BW?
EW.
I'm not sure what that, but yes, you are correct, Your Honor.
Okay, so whether it's a salt marsh or not, if it's within 50 feet of the boundary of the wetland, then it's within the no disturb zone. Is that accurate?
Yes.
Hear from the commission.
Good morning. May it please the court, my name is Amy Questle. I represent the Town of Harwich Conservation Commission. I would like to clear up a few things that were just stated. First of all, in plaintiff's brief, he actually cut and pastes my email to, this is regarding the waiver, and this is regarding his claim that the Conservation Commission would not open the meeting would not open the public hearing without the waiver. I specifically state in that, I suggest that the hearing still be opened in order to comply with the Act, as the Act does not provide for double filing fees in an after-the-fact NOI. And then the Commission can request a continuance so that the applicant can cure the deficiencies in the application. It would be helpful for the Chair to have a list of deficiencies. If the applicant refuses, the Commission will need to close the hearing and issue a decision within 21 days. Therefore, there was absolutely no intent that waiver was required to open the hearing.
Where's that point? What was the site for that?
It is in his, it's in the appellant's brief, page 18. So with regard to a waiver, the Garrity case is quite clear on waiver. And as Justice Sachs has already pointed out, the difference between this case and the Garrity case is that in the Garrity case, there was a checklist. And on that checklist was a waiver. If you don't sign the waiver, your application is considered incomplete and we will not hear it. That is not the case here in Harwich. Furthermore,
well, let's assume you did a great job in your letter, but he's still saying they weren't going to be allowed to file if they didn't sign the waiver.
oh no, they could have filed. There's no question. There's nothing in the record and there's nothing in the brief that says that we will not take that. They would have taken it. In fact, Your Honor, I've had commissions that have, with no abutter notice, with no check, they open it up, they automatically continue it, and if they do not get the information, they then deny it for lack of information. Cities and towns have learned. They've learned from Oyster Creek, they've learned from Boston Water, we've learned. So that is what they do. So the waiver, with regard to the waiver, it absolutely was not required. It was voluntarily executed. It was reasonable in duration. It went from the hearing was supposed to be on June 7th. They couldn't get him in on June 7th. They put him on for June 21st. Now, a waiver has to be, it has to be available to the public. It was part of the public record, no question. It was in the file. Anyone that walks into the conservation office can look at it. And then again, the waiver has to be reasonable. We were talking 13 days. That was it. So the same, the consent of the applicant, in fact, the applicant, or his representative, I should say, when finally before the commission, acknowledged that the application wasn't complete. So the commission did take in an incomplete application. So with regard to the waiver, I think it's clear that the waiver was not voluntary, and the Garrity case would definitely control in that instance. Also,
So just sticking on, he has two waiver arguments. So he's saying they opened the hearing and then they continued it without approval. What's your response to that?
my response to that is the Wetland Protection Act regulations, 310 CMR 1005, allow a commission to open the hearing and continue it without consent for 21 days. They continued it for 14 days. And I do want to clear up one thing. I previously said they were supposed to, I previously said they were going to open it on June 7th, or yes, that they were supposed to open it in by May 25th. They opened it June 7th. They then continued it to June 21st, which is only 14 days. So they had complete authority to do that. The Garrity case has to do with the waiver. However, the Garrity case also has to do with the burden of proof, which he stated that the Bourne v. Austin case stated that the burden of proof is on the Conservation Commission with regard to an enforcement order. That is not the case. Under Garrity, it's clear that it is the plaintiff's burden with regard to an enforcement order. So I did also want to clear that up.
So if we disagree with you and we think it's on the commission, does that change the outcome?
No, it does not. The commission has more than enough. They've met their burden, clearly met their burden. The burden that what they have met is that there is a structure, 10 by 12, 8.5 by 32. There is a structure in the no disturb zone. That structure was not permitted. There was no wetland permit under the Wetland Protection Act. There was no permit under the wetland bylaw. There was no building permit. This was completely.
Could you just clarify for us, looking at a diagram, and the one I have in front of me is Record Appendix 3, page 105, I see a porch that's within the 50 feet no disturb, and I see a small corner of the covered walkway. I don't know.
So,
what's the 12, is the 10 by 12 porch on the north side of the
correct.
house?
Yep, correct. It's, the addition is in between existing cottage, existing house, and the porch is along the front of existing cottage.
Where it says porch.
Yep, yes, yes.
Okay. So the addition is the one that connects the two?
Correct.
And there's just a little corner of that goes into the 50 feet. Is that correct? Just the kind of the south, or the east corner of the structure?
That is I think that 50-foot line, I think you are correct, but I think that's coming off of a different wetland. So there's wetlands surrounding 3 sides of the property. And in any event, looking at this plan, Your Honor, it is 9 feet from the wetland. It doesn't matter if it's a salt marsh, if it's bordering vegetated wetland. It is 9 feet from the wetland. These plans were submitted by the applicant.
That's 9 feet from the wetland.
The edge of the porch.
The
closest point.
The porch that goes across the whole front of the whole side of the existing cottage, or the little stairs?
No, the porch that goes across the front. And so going to, as you know, it is very common to have 2 decisions with regard to a notice of intent, 2 orders of conditions, one under the Wetland Protection Act and one under the bylaw. The reason for that is because the bylaw is much more stringent than the act. The bylaw was enacted by the legislative body of the town of Harwich, by town meeting, and this has already been determined in the Bardsley case by this court, where the Bardsley case determined that the 50-foot no disturb, which was enacted by the bylaw, so that means that town meeting enacted this 50-foot no disturb, and that is a no disturb zone. It is under wetlands. It is not a zoning regulation.
So he's saying it was already disturbed in the sense that it was a lawn.
Correct. But that doesn't mean that you can further disturb it by putting up a structure, which is obviously completely different than a lawn, with regard to, you know, flood storage, erosion, all of the interests protected by the bylaw and the act would conclude that a structure clearly is worse than a lawn.
What was the case that you cited just now before?
Oh, Bardsley.
Bardsley?
Yes, Bardsley versus, actually, ironically, Bardsley versus the Harwich Conservation Commission. It had to do with the 50-foot. It is cited in our brief and provided in our brief. It's attached to our brief. The other just clarification that I wanted to point out is that the Doobie case in Bridgewater was only under the Wetland Protection Act.
It was also an unpublished case, too, I believe.
It is, correct.
Could I ask a question at some point about your res judicata or
Yes.
argument? So it seems to me that what was decided in the first Superior Court case was that the construction was unlawful under the no disturb zone.
Correct.
But what was at issue in the second case was whether the plaintiffs could get a variance or an after-the-fact, file an after-the-fact notice of intent and order conditions or no conditions needed or whatever. That issue wasn't resolved in the first case, was it?
It wasn't resolved. The issue that is similar is the fact that there is an illegal structure in the no disturb zone.
That is settled for purpose of the second case, but you don't contend that every issue in the second case is controlled by the first judgment.
I do not, and neither did Judge Callan, because Judge Callan did state that while issue preclusion is here, I'm also going to do, rule on the merits, and he did rule on the merits, which is the fact that a variance is to be granted sparingly, and the denial of the variance was not arbitrary and capricious. A variance can only be granted under the bylaw, under the regulations, if it is a structure within an existing footprint or maintenance, and that is quite clear. It's been cited in both of our briefs. So Judge Callan held that no matter what, the commission was not arbitrary and capricious when they denied that variance. There is also, as you know, there's case law out there that says that variances should be granted sparingly.
So is it enough for the commission just to say, well, we don't see any evidence of hardship or special circumstances that would warrant a variance? We don't see any potential taking that we need to, it seems like a kind of a formulaic rejection of the variance request.
In this instance, Your Honor, the commission also determined that there was no alternatives offered. So there was no alternatives analysis. There was nothing saying, hey, we need this and this is the only place we can put it. In response to that, we will provide, X, Y, Z of, say, mitigation or something. The applicant did not bear, they didn't meet their burden for a variance, quite honestly, in that case.
So what about his argument that under the AG versus the Barnstable Old Kings Highway case, that it had to be the selectmen, which is a sexist term, but not the commission to bring the litigation, and that wasn't met here? What do you say to that?
So I was actually just going to get to that. First of all, I think we need to remember the commission is the defendant. So the commission is the defendant. The commission is represented by town council. The select board control the litigation budget of the town. Therefore, allowing town council to represent the commission, they have the authority from the select board. Furthermore, if the case were to be that a conservation commission could never issue counterclaims, the first thing that would happen is if somebody thinks that they're going to have an enforcement order put against, sent against them, they're going to rush down to court, file an action in cert, and then the commission cannot counterclaim. It's nonsensical. And in the Barnstable, I got distracted, I'm sorry. In the Old Kings Highway case, that was an issue where the authority, being I think it was the town council of Barnstable, and that's council CIL, they did not approve of using funds for the defense. And that's the same as the Marshfield versus Pembroke case, where the Marshfield Planning Board went to sue the town of Pembroke, and they did not have authority from the select board. The thing that you'll note in both of those cases were that the board was the plaintiff. That is not the case here. Furthermore, I actually, under the Wetland Protection Act, it's clear that the Conservation Commission can issue enforcement orders. Justice Nickerson, or Judge Nickerson in this Barnstable Superior Court noted that in plaintiff's motion to dismiss, plaintiff cited the Wetland Protection Act, but failed to cite the following language that stated that the Conservation Commission had the authority. Further, under the Wetland Protection Act, there is a form, Form 9. Form 9 is the enforcement order, and that is on Volume 1, page 49, I'm sorry. And the enforcement order says, Conservation Commission, you're supposed to fill in the line, and then it says in parentheses, issuing authority. So clearly, the Conservation Commission has the ability to issue enforcement orders. Do
we have to resolve that? I mean, if what was determined in the first action, regardless of counterclaims, that's where the counterclaims were, right?
Correct.
What was determined was that the the construction of those two structures was unlawful in the no disturb zone, and then the plaintiffs apply for the after-the-fact variance, and they don't get it, and that's the subject of the second. How do the counterclaims even come into it?
Your Honor, I don't necessarily think that they do, except for the fact that the plaintiff is claiming that, or the appellant is claiming that they were not lawful. But there is you are correct, there is the after-the-fact notice of intent, which could have been filed at any time. You don't need an enforcement order first to file an after-the-fact notice of intent. So if there's nothing else, I would rest on my brief, as I'm out of time.
All right, thank you very much.
Thank you very much.
Our next case is 2024 P487, CARUCCI versus CARUCCI.
Go ahead. Good afternoon. May it please the court, my name is Melissa Victor, and I represent the appellant Christina CARUCCI. This appeal arises from a January 30th, 2024 order of the Bristol County Probate and Family Court, which awarded my client $150 per week of alimony, or $7,800 annually, following a 17-year marriage. There are multiple legal errors I wish to bring to the court's attention. First, the probate court in 2024 improperly treated this case as a modification rather than an initial determination of alimony.
So I don't quite understand what your point is with that, because the judge did find that there was a material change in circumstance. So what difference does it make?
Well, the difference here is that an initial determination of alimony, it affects the burden of proof, the evidence considered. Here, while the judge did go through the statutory factors, you'll see that he basically only repeated facts about all of those situations and did not take into consideration the full effect that each of those factors should have had. So I do think it's a very important distinction here, because if you look back to the original judgment of divorce nisi, the judge declined to order any payment of alimony at the time, and he said—
Wasn't that a decision?
I'm sorry?
The original judgment said no alimony.
It says the court declines to order payment of alimony at that time.
So that was the second action was to modify that.
Well, I don't think you can necessarily have a modification in a case where no alimony was awarded. In fact, in this
appeals court in 2014 in Videsky versus Videsky, the appeals court faced pretty much an identical situation. In that case, the divorce judgment reserved alimony to be heard at a later date. Years later, one party sought the award, and the appeals court made it clear in that case that when a divorce judgment reserves alimony for a later date, such complaint seeking support must be treated as an initial determination, not a modification. The court explained, because the judgment of divorce nisi reserved the issue of alimony, there was no alimony order in effect, and the wife's complaint was properly treated as a request for an initial determination, not a modification. And the reason why this is important is, in the judge's 2024 decision, he made that alimony award retroactive to 2019, which means, if you look, he ordered 166 months of alimony, which in my opinion should begin January 30th, 2024, which would lead us to an ending date of 2037. But effectively, in going back to 2019 and doing 166 months from that date, now my client is only getting alimony till 2033, which effectively penalizes her for 4 years of alimony, taking away from her $31,200.
Is she getting a retroactive amount that's equivalent?
No. Basically, it says it's going retroactive to 2019, but she's not receiving $31,200. All the court did was say, we're going to start it in 2019 and we're going to end it in 2033, effectively taking away 4 years of which she never received alimony payments. She received child support, which is required by law, and she should not be penalized for the fact that he was paying child support and not alimony at that time. So that's the major problem here in determining that it's a modification as opposed to an initial award, is the retroactive and the loss for my client of 4 years.
Is this in your brief? I didn't catch this point.
Well, the retroactive part I don't believe was in the brief that was submitted, but
You're not the author of the brief?
I'm not the author of the brief. Okay? The second and huge issue here is the probate court improperly calculated my client's income, which is huge. So if you look at its findings from January 30th, the trial court found that my client's weekly income was $666.51. And if you look, it includes her SSDI payment of $301.16, her SNAP benefits of $65.31, and her temporary alimony award of $300. This calculation is clearly erroneous because the $300 was a temporary alimony, which was a transitional payment pending trial and obviously terminated upon the entry of this new judgment of $150. So they utilizing a $300 temporary payment that she's no longer receiving is completely incorrect.
I see the error there. Are you saying they shouldn't have considered the SSDI, or is it just the SNAP?
No, I'm saying they can consider the SSDI. The $300 alimony payment should not have been considered, and neither should the SNAP benefits, because the alimony statute uses the same as the child support guidelines, where it does not utilize means-tested, public-assisted programs. So in actuality, my client's actual income is $301.65. And, and then what the judge did is he argued that and concluded that she should take a portion of her pension and retirement assets as a means for her income. And under 53 section C1 and Zaleski versus Zaleski in 2014, any income derived from an asset equitably divided between the parties cannot be included in income calculations for alimony.
I didn't follow you on that one. I don't think 53C1 says any income, does it?
So what happened here is that they're trying to suggest that because she got part of Mr. CARUCCI's pension and alimony from retirement, that she could take that pension and take from the annuity to support herself. But as the court is aware, if my client withdraws from any portion of her annuity, she's 52 years old, not only is there a 10% penalty that she does for taking it early, but it's also an income tax situation.
Well, maybe that would need to be taken into account when setting alimony and figuring out how much she nets out of that. But are you relying on 53C1?
Yes.
That says exclude capital gains income and dividend and interest income which derive from assets equitably divided.
Right.
So this isn't capital gains income or dividend or interest income, is it?
Yes, but the court cites Carbonneau from 2018 and Champion from 2002, okay, in order to include these. In both those cases, both parties had substantial retirement assets. They both had long careers. They both had comparable earning capacities. In contrast here, my client has no retirement savings of her own. She spent the duration of her marriage as a stay-at-home mother. She clearly lacked the earning potential or capital accumulation that Mr. Carucci had. And not only did the judge say she should include her 1026 of income from a pension, if she takes it now, it's a lot less than if she takes it later on. But where is the same factor for him? Why wasn't his pension and his annuity what he was going to get calculated in the alimony order? It seems to be very prejudicial to my client to have to split assets and then have to use those assets while the court didn't basically say the same for him.
Was there any evidence of what his payments would have been or whether pension payments would have been available to him?
I don't even believe the judge asked about it. They just basically...
But, whose burden is it?
Well, I mean, I think I think I have a piece of paper that shows what his may or may not have been, but honestly, I don't know if it was taken.
If it wasn't put before the judge, then how could the judge be faulted for not taking it?
Well, because I think the fault is that he just said, well, she can take it. Wouldn't it just make sense to follow through and say, well, so could he? I mean, if you're going to use it in her income, why wouldn't you include it in his income?
Maybe it makes sense, maybe not, but without evidence of what he could actually get, how could the judge take it into account?
Well, he couldn't. So let's assuming arguendo that he didn't take it into consideration and that he did, which he didn't, right? If you look at the guidelines for alimony, it's very clear. It's based on either the person's need or they have a statutory guideline of 30 to 35%. If you look at here...
That's not a floor, though.
It's a guideline.
It shall not exceed the
Correct.
need or 30 to 35%. It doesn't mean that there's something wrong with it if it doesn't get to...
100% agree. However, if you look here, the disparity is my client's getting 8%. Okay? Nowhere near, and that does not even support her need. So, basically, if you even look at at the brief, page 14 of the brief, talks about if you use different percentages and what those would be. Okay? It's a lot higher than $150 a week. The other thing is that Mr. Carucci clearly has the ability to pay more money, which should have been taken into consideration, because he was paying $482 in child support for those years. And then when child support ended, he was actually paying $300 in a temporary award. Not just that, but the court utilized outdated and inaccurate financial information. He submitted...
Was the court asked to order him to submit an updated financial?
No, not to my knowledge. My client did, but his didn't.
Was that a waiver?
Huh?
Was that a waiver of that then?
I honestly don't know. What they did was they relied on the November 2022 statement, which was clearly incorrect. His 2021 W-2 reflected income of $159,000. He only reported $117,000. The fact that, they used old financial statements should be error, right there.
But I don't see the husband's financial statements in the appendix. I saw the W-2.
Well, those are impounded, so I'm not sure how they would have gotten to the court or how that was.
If they're usually filed in an impounded appendix.
Yeah, so this was done under the program of a pro se person the new program of somebody submitting briefs.
Informal brief.
Yes.
So you identified a lot of what you say are problems with the judgment. We can't fix these all on appeal, even if we agree with you. What do we do here where apparently the judge has retired? What would we order?
Well, I would suggest that you remand this back to the probate court to use the correct, correct amount of income to take into consideration an initial alimony award,
Does there
utilize...
need, I guess, larger question, does there need to be a new trial, in essence, on this modification complaint? Because this is a very discretionary judgment, and whichever judge would get this, if we remanded it, would not really have the familiarity. I mean, even if I suppose they can read the transcript of the original and read all the evidence, or do they need to take new evidence?
I mean, I think an initial alimony award things should be taken into consideration. I think we can agree. The income of both parties, the expenses of both parties, a contribution of each spouse.
Yes, I'm asking you, what relief are you asking for?
Well,
do you think the judge, if we remanded, should be required to take new evidence, including sort of up-to-date evidence? Or should the judge just go back and redo this based on the evidence already in the record?
I think that we can agree that under the divorce statute, I think it's 53E, that the judge was supposed to make very justifiable written explanation as to why he or she deviated from the standard. I see no justifiable written explanation in this order except facts. And the one thing I really want to bring to the court's attention...
That doesn't answer the question. And are you looking for, in essence, a new trial or new evidence to be taken?
Well, I mean, I guess I would love for you guys, for the panel to be able to award an alimony amount. But if that's not going to be the case, then I do think it needs to go back to the probate court to take into consideration all the appropriate factors. And one...
Again, you think there should be new evidence, or just take into account the appropriate factors based on the evidence that's already in the record?
Well, I don't think the factors changed. I just think that...
But the facts, you've identified evidence that's missing that you wish had been submitted. You've identified other things. Is there a justification for reopening the evidence here?
I do think there is, because while I submitted evidence of different things, I think a lot of these things were submitted at the probate court level. For instance, my client left her full-time career as a phlebotomist to be a stay-at-home mother, which helped critical to the success of her husband, who was a master plumber, who built his pension, who still has the ability to build his pension. And she's effectively being penalized here for being a stay-at-home mother because she wasn't able to add money to Social Security or to put money in an IRA account. I don't think the judge took into consideration the things that were supposed to be taken into consideration under an alimony award. And if he did, there are no findings in here to suggest why he deviated to an 8% difference as opposed, to something close to a standard of what she was getting in child support and or the temporary alimony award. So she's been penalized for being a stay-at-home mom, has no means of retirement, and now the judge wants her to use her own retirement that she got by helping her husband by being a stay-at-home mom to her own detriment. So, I think in conclusion, yes, I think a new alimony award is necessary, but if that means remanding it to the probate court to further review and utilize the appropriate standards, the appropriate income, I think that that's what's justified here.
All right, thank you very much. I think we understand your arguments, and we'll hear for counsel for Mr. CARUCCI.
Good afternoon. My name is Stephen Merlin. I am the husband's attorney, and I was also the trial attorney for the husband in case Justice Sachs had a question about that. I filed a financial statement within a week before the trial took place. I don't know what the judge used. But I feel like I'm in a different case than what we're talking about here. And the judge listed all the criteria that he was supposed to in determining an alimony award.
This award is, so let's just break it down. Did the judge improperly consider the SNAP benefits? Because I don't see you answer that in your brief.
The answer is, I don't know where it's excluded. So it's up to, I don't see where it's excluded. And I don't think the judge did. And I'll tell you why, Justice Henry, if you give me a second. Here's what I see. I see the following, if you will allow me. The statute, as Justice Sachs says, the needs of the recipient are 30 to 35%. So in the findings, the judge said the needs of the recipient are $700 a week and change. Now, where did that number come from? And that number is not being challenged anywhere. Sister counsel did not just challenge that number, or did anyone else. That number is not taken out of a hat. That is taken from her financial statement that she filed at that time. The financial statement is a probate court rule. I think it's supplemental rule 401, income and expenses, assets, liabilities. And judge concluded after trial, based on her financial statement, her needs were $701 and change. Now, what did the judge do? Here's what I see the judge did. I see the judge took the Social Security, which he's clearly able to do, as $301.16 towards that $701. And at the end of the trial and in my supplemental appendix, there's this whole big discussion about the pension because the wife had applied for the pension, said she was taking the pension. The pension was $1026 or $238 a week. You add the 301 and the 238, you get $539. Now, you can take the SNAP, you can do whatever you want. Judge only has to get the wife to $701. So if you subtract 701 from 539, whether you count the SNAP or don't count the SNAP, and there was a whole discussion in the on my examination of the wife about the annuity, if you took this, so forth, the annuity was there, and the judge has the right to consider that she has the ability to take some of the annuity.
Then why doesn't the judge also consider his ability to take the income?
Okay, the answer to that question is very simple. It never came up during the trial. My client was examined by competent counsel. There was no cross-examination of him over what he would get from his annuity if and when he took it. Sister counsel was correct. It was a quadro. It was divided 50-50 at the time of the divorce. And so therefore, the judge had no information on which to consider that. The judge just can't arbitrarily say that, oh, I'm going to consider that or not consider that. He didn't have any numbers. And whose fault is that? Wife did not cross-examine on him.
Well, but, I mean, we have a situation where, she is being evicted for non-payment of rent, and he's building a $700,000 house. And the judge, just by common sense, has to know if she can get X amount of money out of this pension, then so can he. Like, he might be able to get 2 or 3 or 4 times that, but he can definitely get what she can get. And that doesn't seem to have been taken into consideration.
So let's look at it this way. Let's assume that he could take the money out of his annuity or out of his pension. The problem in this case is the wife locked herself in by saying my needs on her financial statement are $701. That's the number the judge has to reach. It's discretionary. He could have said, as sister counsel said, they were married so many years, I want to give her a bonus points here or there. But he followed the statute.
Do you know if that's where that is in the record? And I recognize that she had more of an obligation on that than you.
Sorry, Justice Henry, I didn't catch the question.
Where it is on the record that her need was $701.50. I see there's a finding on the record appendix.
That's based on the financial statements, which unfortunately you do not have. But I can say the judge's finding, Judge McMahon is retired. His findings were always fairly careful, leaving this one aside in someone's opinion.
Well, it's adequate, though, that he had made specific enough written findings, because opposing counsel, the wife's counsel, is saying no. He didn't make written findings to justify the deviation to 8%.
I don't consider it a deviation. The statute says the recipient's needs are 30 to 35%. In my footnote, judges now use around 24% because of the Tax Act and its non-deductibility of the alimony. But I don't consider that a deviation at all.
Did the judge properly take into account the differential in the ability to preserve the lifestyle enjoyed during marriage?
In my brief, I put when wife was living in the apartment after the house was sold, that she had a pool, she had a clubhouse, she had a better lifestyle in the apartment than she did in the house. I can make that argument very, very, very plainly. Husband was in the middle of building a house. He had a right to do that. They got money from the sale of a house. There were 2 adult boys at the time, and the boys were going to live with him. His mother was going to live with him. Not in the record, so maybe I shouldn't say that. They say he was building a house. The difference in the cost of housing, we all know what that is. I don't need to prove that.
Can I ask a separate question? Did the judge take into account the pension payment that he said was available to her of $1,000 and something a month starting, I guess, the January after the trial? Because I don't see where that entered into his calculations. I see he says it's available, but it doesn't seem to be reflected in income.
My understanding of the decision is what I said before. You got Social Security, the equivalent of $301 a week. You got the pension. There was a whole discussion that she was taking the pension. There was a whole discussion about how we were going to get that information in. We have a letter in my record appendix from her lawyer to the pension company saying, we need this information. We got the information. It's monthly. It was $10.26. I divided it by 4.3. You get $238. In my way of thinking, the judgment says Social Security $301, pension $238. That takes us up to just under $550, and then he gave a $150 order, leaving aside whether the annuity could or could not be taken. And I made an argument in the cross-examination that she could certainly take it. I don't think the SNAP is necessarily excluded, but you don't have to include the SNAP in there. That's where I see the judge got the number.
Right, but you, go ahead.
Where did the judge take the potential income from the pension into account? Can you point to a finding of fact where he determines her income and says it includes?
He said she has available the pension. Page 8 probably. Let's see.
Page 4 of his findings, which is Record Appendix 1, page 39.
Yep.
Finding 37 is mother's total weekly income is $666.51, which he says gets to by including Social Security, SNAP, and the court's temporary order of $300 a week. So I don't see where the potential income from the pension, let alone the annuity, is included in that.
There is there. In the rationale on page 6 at the bottom, the court finds that the mother can currently receive at least $10.26 per month through the pension plan. The last paragraph on 6. Yep. So I've been reading this in the light most favorable to the wife, in my own mind, saying Social Security 301, pension, divide that by 4.3, 238, takes you just under 550. And the judge gave a need to meet her expenses. And on top of that...
What's your best case for the proposition that a judge can basically force the spouse to draw early on a pension, obviously then to her detriment later on?
My understanding of the way the trial ended was that the wife said that she was taking it.
Well, she was pretty desperate for money.
Oh,
I mean, it's a terrible decision for her to take that money.
Not in the record, but in the docket sheets, if you look back, you will see that the wife refused to sell the house, and the court hired a master to sell the house at her expense, and she lost $20,000 to $30,000. That's in the docket entries. If I had known we were going to discuss it today, I would have put that as a record appendix. She blew money, and it was the same judge throughout. Thank goodness, probate and family court, you usually have the same judge throughout a case, barring something unusual. And that was part of, that's part of the record, at least in the docket sheets that you have, that a special master was appointed at her expense to sell the house because she refused. And the judge knew her history, and in the divorce decree, which is in my record appendix because it was not there, there was an agreement in part, and the alimony was separate, as you recall, when the judge made no finding of alimony, and that is a no finding, that the judge actually lowered the agreed-upon child support there because he basically said, mother's not going to pay the college expense, so I'll deduct it from father's
But that became, I
money.
mean, everything broke the husband's way, right? Because he could have escrowed that money, but instead he says, okay, the father's going to pay less because I'm going to presume the father has a college cost, but then one kid doesn't go to college and one kid drops out after a year, so there's a windfall for the father. Then he's counting the SNAP benefits when it seems like the statute says he shouldn't. I mean, like, what didn't go for the husband? Everything seemed to have gone his way. Even if the wife was misbehaving, she's now seemingly living in poverty, or at least now has moved back in with her mother. So maybe she made some poor choices part of the way, but then she got religion and she is living with her mother to save money.
I'll respond to that in this fashion. Statute says the needs of the wife are 35%. Okay, the needs of the wife, as I said before, came from her financial statement. That's not challenged by wife in these proceedings in her brief or anything. So those are the needs. That came from the financial statement. She filed the probate court supplemental rule 401 financial statement. That's under pains and penalties of perjury. That's signed, and she had counsel sign it. Counsel doesn't certify the numbers are true, just saying this is what my client says are the numbers. The judge matched the numbers, in my opinion. I've said it 2 or 3 times already, said I have to give her $150 a week to get up to her expenses.
I do think we understand that point, and that was actually a very helpful point for you to explain. The husband testified that his 2023 income would, quote, probably, would be, quote, probably around $150, which I assume he means $150,000. The judge found in the written findings that his weekly income was $2,712.76, which works out to $141,000. How's that not an error?
Okay. Without having the financial statements in front of me and the exact transcript, I cannot answer that, Judge. However, Mr. CARUCCI's husband's income was based on base pay, double pay for some times. It was based on COVID pay at some times. It was based on overtime at some times. Some of it was being estimated, so if he testified, some of it might have been an estimate that he was on track to make 150, but the judge found that he had made 141. I know I got 30 seconds left. I was trying to find something that let me see. If you bear with me for a few seconds, please. Somewhere in here, I thought the judge said that the wife's needs were only $650. But anyway, I've said that. I said the same thing a number of times. I don't want to take up more time.
Maybe 2.
Or maybe 2.
Well, maybe 1 from the...
No, she's good.
So assume that we agree with the wife that it was error to include the SNAP benefits in the calculation of income, that it was error to include the temporary alimony of $300 a week in the calculation of income, her income. That error might be made up for partially by the pension payments that are available to her, which would average out, I think you said $237 a week?
$238, yes.
$238. But that doesn't quite make up for the error. What should we do if we think that something wasn't done right here? Do we have the information that we need to recalculate this, or do we need to remand it? And if we remand it, should the judge be able to take additional evidence, particularly since it would be a different judge?
So Judge McMahon's list went to Judge Moses, so Judge Moses would pick up the case. Because you are dealing with finances, the court in no way, in my view, could rely on finances from 2 years ago to calculate a current amount of alimony now. So either you uphold it and saying, I may not like it, but it's not an abuse of discretion, or it has to be remanded for a new trial based on current numbers. I don't see any other outcome. I know sister counsel was hedging a little on it, but I don't see any other outcome, because when you're talking dollars and cents, it's today's would be 2026, 2027 dollars and cents.
All right, thank you very much.
Thank you.
Case
Thank you
is
for the extra
submitted.
time.
Our last case for today is the Department of Children and Families versus Child and Others, case number 2025-P0202. I will remind everyone to use pseudonyms. Really best just to say the child, father, mother, and observe that impoundment order.
Shall we just wait till they get out?
Just give them a minute here to. All right. Well, actually, if we could just wait, because the door makes a lot of noise. There we go.
Good afternoon, Your Honors. Attorney Svetlana Gerova-Wilson. I represent the child, the appellant child in this action. My pronouns are she, her. Your Honors, I'm sure you have read my brief and reply brief, but I wanted to put the stress on something. In the world of care and protection proceedings, we talk about parental rights. We talk about termination of parental rights, and yet we say it is the child's best interest that is paramount. I suggest to you that in some cases like this one, where there's nobody else sitting next to me, there's no parent here trying to challenge a termination, that in cases like these, we should look in those cases as termination of a child's rights to a legal parent or termination of filial rights.
Can I ask you, what do you say to the department's argument that this case shouldn't even be heard by us because the father's not here, he hasn't appealed?
So, Your Honor, and this is the reason why I was asking this court to actually make published findings, because this EF is correct that there's no case law that says specifically the child has the right to appeal where the father is not appealing. However, the child does have the right to start a judicial proceedings adjudicating father as legal parent. He has a right to counsel. He has a right to appeal, a right to appellate counsel. And I was actually taken aback a little bit by that statement that a child does not explain how the relief can be granted when the father is not appealing. So the child is not forcing father to take custody of him. The child concedes that this father is not fit, at least for the purposes of the statute of the statute in question, because he's not a good dad. I mean, this is the first prong of the analysis, whether or not there's clear and convincing evidence that is fit. That is not fit. That is not there. He's not a good father, at least, that's what the evidence shows. He has not participated in child visits in the last couple of years. I mean, at the time of trial, I don't want to bring anything up.
You're not challenging unfitness. You're challenging
not challenging unfitness. Yes, I'm challenging best interest. And what is best interest? The best interest would require an analysis whether or not there's any benefit of the to the child of terminating those rights, or balanced against any detriment to the child. So I don't know how to word this. There's not a single thing that the judge stated that would benefit the child if that's rights are terminated. The judge is talking about freeing the child for adoption, and I was actually shocked by this, because at trial, the judge said, well, why are we asking questions about adoption? We're not trying to get this child adopted. He was 14 years old at the time. He's almost 60. He'll be 16 next month. He's not getting adopted. The goal is not adoption. DCF did not offer adoption. The judge did not find that adoption is in his best interest. Then she makes a finding that terminating dad's rights would free him for adoption, yet doesn't free him for adoption because she doesn't terminate mom's rights.
So doesn't she say that it was in the child's best interest to terminate, to give, I think she writes, to have caregivers who will be there for him to free the child to form positive bonds with those caretakers, and that's the conclusions of Law 30. So is that enough? Is that sufficient in terms of
No, Your Honor, I do understand the argument, and in many cases, it might have been sufficient if it was a child who's getting adopted, who's getting freed for adoption, but it is not sufficient, and frankly, I don't see how can she even state that, because she's not freeing the child for adoption. If there's a deterrent of accepting a foster child who's not free for adoption,
but what about
it's still there.
But not putting aside adoption, she's saying, well, to free the child to form positive bonds with those caretakers, right, the people who are caring for him. So I suspect that the department's going to stand up and say, well, the father hasn't been around, but we don't want him to somehow resurface and interfere with whatever's going on with the child, and somehow, even though there's no evidence that I think that he would necessarily, because he's been largely absent, right, in terms of the last few years of the child's life. But what do you say to that argument? Is that sufficient?
Your Honor, it's clear and convincing evidence, and there's no evidence that would happen. There's simply none. I mean, not a shred of evidence that this child's legal relationship to his father is going to in any way interfere with his bonding with substitutes.
Does clear and convincing evidence standard apply to the best interest determination?
Yes, Your Honor,
or
both.
only to the fitness determination?
It applies to both.
I see some inconsistency in the case law, and where the best interest determination is so discretionary, I'm really wondering how we figure in clear and convincing evidence.
So, Your Honor, I don't even believe that the department is challenging the standard, but it is. I mean, it's ever since I've been doing this, it's always been clear and convincing for both prongs. So,
let me ask you about another sort of point of law. The case of adoption of Nancy, which I know DCF cites, and I think you may have cited as well, has some odd language in it that jumped out at me. It says they're reviewing a termination, and the SJC says, while not specifically stating the reasons that termination was in the children's best interest, the judge's factual findings were specific and detailed, demonstrating that close attention was paid to the evidence and the 14 factors listed in 210(3)(c), which are fitness factors, not best interest. Then the court goes on to say, although it would be better practice specifically to state the reasons that termination is in the child's best interest, such specificity is not required. The judge had discretion to conclude that termination was appropriate. It's implicit in the judge's findings that termination is in the best interest. So, given that language, what are we supposed to do with a decision like this one that doesn't clearly articulate how termination is in the best interest?
So, Your Honor, in Nancy, the goal was adoption. These kids were, adoption was found to be in the best interest of the children, which is a huge difference between that case and this one. It may not be differential. I mean, are you saying that the judge has to make absolutely no findings of best interest?
Well, I'm not
no
saying
specific.
it. I'm just
I don't think Nancy says that. That's what I'm trying to say. I don't think that Nancy suggests that the judge is given so much leeway as to say, well, I think it's in the child's best interest, and that cannot be challenged. But most importantly, the judge not only did that, she made multiple legal errors. And the department even agrees that she did. For example, the judge said, and I quote, because it was really shocking statement for me to read by a judge who's been on the bench for several decades, and I've been in front of her for 9 years. Not on this case, I'm only appellate counsel, but she stated, the child is 14 years old, and his legal rights remain intact until and unless he's adopted, even after termination. This is simply not true. So even sister counsel agrees with me, the child does lose the right to child support.
But do we need to reach those issues, I guess, because isn't there a separate, I understand what you're saying, and I appreciate that the department conceded that there was error of law with respect to some of those issues, but do we need to even, how does that play in the calculus, right? The department says, well, it doesn't really matter whether there was error or not, but because in their argument there was enough here. I know you're saying there wasn't enough evidence to support best interest of the child. I found it interesting that those issues were mentioned, but do we need does that play? How does that?
Well, it does play, yes, Your Honor, I believe it does, because the judge made her finding of best interest based on misconstruction of the law. And I think that is important because I believe it would factor into her decision to make a finding of best interest of termination of parental rights.
So I mean, the judge says in a number of instances, well, termination wouldn't cut off the child's rights to this, that, and the other benefit. I think that the parties have agreed that the judge was wrong as to support, but as to some of the others, it may very well be that adoption is what cuts them off. But if termination doesn't cut off those rights, does that weigh in favor of termination, or does that mean that termination just doesn't do that particular type of harm?
So it doesn't necessarily mean that if it didn't cut off these rights, it didn't necessarily mean it was in the child's best interest. We need to weigh the benefits of the termination and the detriments. So those are the potential detriments, right? But if there are no benefits of the termination, I submit to you that even if there are no detriment, the lack of benefit is sufficient to overturn the decision, because the judge still needs to find something, that this termination is going to do something for this child, something positive to further his best interest. And there isn't anything.
Well, I think the issue is, you know, sometimes the department does come up with an adoption, even for an incredibly hard-to-place youth. And, you know, at some point, this youth could change his mind, and I think the department's position, what we'll hear from them, is that, you know, removing an impediment to adoption, even if we haven't entirely cleared the path, does benefit him. Whereas if he changes his mind a year or two in, then he's particularly because he's so old, he's essentially can't eliminate this father who was not helpful.
So, Your Honor, yes, I understand the argument, and I respond this way. So he was 15 years old at the time this decision came down. He was very clear he does not want to be adopted. Mom's rights were not terminated. He felt the need to have a legal father. That was important to him. It was hurting him in a non-financial way to have no legal father. And in this particular...
Can I ask you about that? We talk about no legal father, you know, orphan, legal orphan, but as you've pointed out in your discussion of the benefits that might be cut off by adoption itself, termination doesn't terminate all legal relations. I mean, he's still on the birth certificate. The child can still get Social Security benefits, intestate inheritance. So there remains a legal relationship. Is there any indication that this child is interested in the legal relationship that would be ended by termination versus the emotional relationship?
If you're asking me whether or not he intends to actually seek those legal rights out about child support, I mean, I don't know if there was anything like that at trial. Trial was 29 minutes, and I don't believe that it was the child's burden of proof to show that he intends to seek child support when asking the judge not to terminate.
I guess let me try again. We frequently talk in terms of terminating all legal relations, but as your arguments highlight, it doesn't terminate all legal relations, or at least termination of so-called parental rights really means just notice of an ability to appear at and object to adoption, guardianship, etc.
And seek child support. And again, I mean,
child support.
And seek child support, and also.
Is there any indication that what matters to this child is the end of the ability to seek child support and a step towards potentially making those other benefits available if there's an adoption? Or isn't what's really important to the child here the sense of emotional bond, which is not actually cut or terminated by termination of parental rights as much as is maybe commonly assumed?
Well, so this child, by virtue of objecting to the termination, due to his age, he understands the difference between legal rights and simple biological, bond. Yes, it's the most important factor for him was the emotional connection with dad, and the very fact that he's legal, that it means something to him. I mean, holding otherwise would mean, like, why do we even adjudicate fathers as fathers, right? I mean, his counsel raised the issue of child support. Whether or not, I mean, he didn't testify saying I intend to seek child support if I go back to mom's custody. But to answer your question, but yes, the emotional side of it was the most important one for him, and I do believe that's enough. That is enough to show that to be considered by the judge, and she didn't really do that. And also another thing, he didn't even have a therapist to help him process the loss, and that I think that weighs in.
I'm sorry, I'm just thinking through your argument. You said the emotional impact was enough, but
it would have been, yes, but there are other things as well.
But what is the emotional impact? I mean, I don't mean to minimize what might be thought to be an emotional impact, but if we're saying, okay, what termination really means is the father doesn't have right to notice an opportunity to object to certain dispositions, and the child loses the right to seek child support. Does that have an emotional impact? Is the child does that actually interfere with the child's emotional connection or desire for connection with the father?
Well, I do believe it does, but I also don't think that the child had to testify as to that. He didn't have the burden of proof to show that. And I do think that even if he never intended to claim those benefits, that he'll be entitled to based on his legal relationship with dad, this is a legal right that he'll be losing. And just losing a legal right in and of itself is enough harm to him to justify, to weigh against termination of parental rights.
Would your client find it acceptable if instead of a termination of parental rights, we adults stopped being stupid, in my opinion, and we said, in fact, the father's, more factual, that the father loses his ability to make decisions about the child or stop an adoption? If we were very literal about what the father loses and that the child doesn't have to lose anything.
Unfortunately, we cannot really do that. This is the, termination of parental rights is the only thing that that we can do. He either has the rights or he doesn't.
Right, but why can't we do exactly that? Terminate the father's rights to interfere with the child and leave the legal relationship of father intact?
Well, the judge already did that by finding him unfit. He's unfit, he doesn't get right to custody, he doesn't have legal custody, he doesn't have physical, obviously, he doesn't have any say in what the child does. The child's custodian has the right to tell the dad no anytime he asks, and I'm so sorry, I see I'm out of time.
No, we asked.
So anyway, the answer is it would, but that would have, that is what I'm seeking. I'm seeking remand only on the issue of best interest and not on unfitness. And the unfitness, the lack of custody to dad carries all those things of that are protective concerns potentially as being able to interfere with anything in the child's life.
All right, we'll hear from the department.
Thank you.
Good afternoon. May it please the court. Julie Gallup on behalf of the Department of Children and Families. I think Justice Sachs and Justice Henry kind of hit on the point that I was going to start my argument with, is that the statute says that, while we say, I don't want to say colloquially, but when we argue these cases, we talk about termination of parental right, but the statute really says, dispensing with the rights of the father to receive notice of or to consent to any legal proceeding affecting the custody, guardianship, adoption, or other disposition of the subject child.
Why can't we enter that order?
Well, that is what the judge ordered.
But why did you all, but what evidence was there that the father was likely to interfere with any court proceedings in the future, whether it was like a guardianship petition or anything else? And didn't the evidence show he was essentially sort of absent throughout?
So, whether he was absent or not, if there is a guardianship petition filed, they still would have to serve him. He would have an opportunity to file an objection. Right. And so, without removing that legal impediment.
Isn't that purely hypothetical in this case? He's never expressed any interest before.
He never showed up. He wasn't at the trial, right? There was notice. He was served, or was it publication maybe?
I think he was served by publication.
Right. So that means that he never was served in hand. He didn't appear for the proceedings. In fact, he told the social worker when they called initially at the removal, right? I think it was 2019. He said, "I'm not able to care for him," and there was no evidence, right, of his presence at all in the child's life. And Furthermore, wasn't there the evidence that the social worker testified at trial that no one had had a conversation with the child about the fact that the department was seeking to terminate the father's rights?
So I'm a little bit unfamiliar with, like, let's say a potential guardianship petition is filed, you have to serve interested parties, and they have an opportunity to file an objection. I don't know my extent of like the proceeding procedurally beyond that it ends there. But like if it wasn't a guardianship or if it was a third-party custody order or type of case, I think you still need to serve the father, and he has an opportunity to participate. And I don't know, let's say it's third-party custody, if in that situation the judge could only order that upon finding the father then unfit because his rights are still intact. He still has an opportunity to participate.
Not if, well, if there was a separate guardian petition filed, yes. He would, if his rights had not been terminated, he still would have to have been served or notice given, right? But here, again, I'm just trying to figure out, this is not a 2-year-old we're talking about, right? This was a 14-year-old at the time of trial, and his counsel objected and said, I, on my client's behalf, I'm objecting to the termination of his rights. And then there's testimony and evidence that no one had ever had a conversation with him about the fact that the termination is being sought, right? And also, wasn't there testimony too that I believe he was asked, the social worker was asked if he believed that severing the legal relationship between them would negatively affect the child's mental health. And the worker said, oh, I don't think so, because he hadn't had much communication with his father. But that could go either, I guess I'm just trying to figure out what was motivating the department by seeking, in this particular instance, when there doesn't seem to be any evidence in the record of the father. Really, he was absent, so unfitness is, not being challenged. He was unavailable. Particularly when the child was objecting and no one had actually had a conversation with him about what his position would be with respect to the termination.
I have like a very similar case, so like next week scheduled for argument, so I don't want to like misspeak and misconstrue the facts, but I want to say that my understanding, I believe there was testimony or there was evidence where basically, in the absence, where you don't have that the legal parent available to potentially interfere in any type of, permanent plan, that does provide stability and it does open up options for the child. And I believe that was the department's thinking. Again, I really don't want to.
Right, so I'm back to the statute, because I think you started by quoting Chapter 119, Section 26. Mm-hmm. And I think what you're saying is that under B4, that the court can enter that any one or more of the following, and one of them is that it may dispense with the need for consent of any person named in Section 2 of Chapter 210. So instead of just terminating parental rights, could we just enter that language, and then there doesn't have to be this emotional wallop that there is when you say you don't have a legal father?
Well, I'm looking at the judge's findings, and I don't know what page of the record appendix, but the last page of the judge's findings, that last paragraph, makes that specific order.
Yeah, but the prior page, number 3, is termination of parental rights of the father. So can we just cut that out and just make the finding, I'm trying to find the language you're looking for, that the father to receive no notice of or to consent to any legal proceeding affecting the custody, et cetera. Because that seems like that would satisfy everybody. I always look for that, get to yes for everybody.
Yeah, I think that is kind of, that last sentence of that paragraph, I think, is the
But that's what the department is trying to achieve, correct?
That's my understanding.
There's nothing more that the department wants than that?
Well, I think that at this point, the department has custody, as custodian, the right to determine visits, which would include, the discretion to have, to facilitate visitation between father and child. I'm just trying to think, I'm thinking while I'm talking right now.
And also here, there was not even, guardianship wasn't even in the cards. There's no record of that, right? In fact, the permanency goal was reunification still with the mother, even though I know he wasn't placed with the mother.
Correct. The goal was reunification. At the time of trial, he was placed with a visiting resource, and there was a finding that, maybe this could be an option, but.
Right. And the department could actually pursue guardianship even without the father having had his rights terminated, right? Even unfitness, even if he was just unfit, the guardianship could still have been allowed.
Yes,
That's
that's
what the concern was for the
There are
department.
cases where, where you can have guardianship without, that would then also open up the opportunity for the father to come back at any time and contest the guardianship where his rights remain intact. But I think that with regard to one of the questions that Justice Sachs asked about clear and convincing evidence, the best interest of the child and unfitness, our case law says these are connected concepts. So basically, when you make a determination of unfitness, you are also considering that termination is in the child's best interest. And in this situation where the father abandoned the child, abandoned the proceedings, maintaining that legal relationship, the judge did not need to consider all of those ancillary issues of support and inheritance and Social Security.
But do you agree the judge needs to articulate how termination serves the best interest of the child? And I read that long passage from Nancy earlier, and I'm curious as to your reaction about that.
Well, I think the judge did do that here, where the judge talked about how basically, removing this possibility of a connection from this child's life, legally speaking, would give him some stability in the face of where.
What kind of stability? I mean, was there any evidence that without termination, the father was going to come and disturb things? I mean, we've seen cases where a parent is litigious and has demonstrated their willingness to go on interfering or pressing their claim, and therefore termination might be warranted to take that out of the picture for the child. But here there's no evidence of that. What's the most specific evidence you could point to here that termination advanced the best interest of the child?
Well, I think I talk about I think it's kind of more by analogy, but the child's responses to issues with mom not being available when he anticipated that she would be, and his response to that. So I guess the judge kind of looked at it in terms of basically, where we keep this door open, the anticipation and possibility of this parent reaching out to have a connection with the child creates just ongoing instability in his life. And by analogy, looking at his emotional and behavioral responses to situations where mom.
But that's the mother, right?
Right, but I'm saying that the response to the parent not being available.
But was there any evidence that the child continued to have that response, that he continued to be anguished or suffer because because he thought the father might reappear, but the father hasn't reappeared? And that he needed to, have the court tell him, send him a message saying, you've got to abandon these false hopes of reunification with your father. You need to move on.
There was a finding that, I don't remember what there were very few, but there was a finding where basically the child told the department that the father was not making contact with the department and the child because he refused to sign some paperwork or something like that. So there was one finding that talked about.
The father refused to sign some paperwork?
Yeah, I don't.
There's just too many he's in that sentence, so.
Pardon?
I said there were too many pronoun he's in that sentence, so I wasn't sure if you're talking about the child or
Sure,
the father.
sorry. I could tell you. The gist was that the child told the social worker that the child believed the father was not making contact with the department because the father declined to sign, I'm sorry, now I'm getting confused, but.
How does termination, I mean, how does that constitute harm to the child that termination would prevent?
I think that it illustrates the child's kind of mistaken belief about the capacity of this adult in his life to be there for him. That, that basically, but for the department, father would be reaching out.
So if that's what the judge was relying on in this highly discretionary determination, don't we need the judge to say so? Because, the abuse of discretion standard is outside the range of reasonable alternatives after taking into account all appropriate factors. We don't really know whether the judge took that into account, for example. And I'm thinking of the case that says termination is an extreme step that shouldn't be taken unless the welfare of the child demands it. Whether or not the clear and convincing evidence applies to the termination decision, maybe even if the interests were slightly advanced as compared to the detriments of termination, did the welfare of the child demand termination here? I mean, that's pretty strong. That's more than just a preponderance, to use a rough analogy.
Well, the judge did make a finding about, and I guess it was not really, it was more perhaps like a recitation of the testimony, but the judge did find that the social worker or, I don't know, some agent of the department had assessed that child would not be impacted by that outcome, and that finding only needs to be proved by a preponderance of the evidence.
But then, didn't the social worker testify that he hadn't had a conversation with the child about, again, the department seeking to terminate the father's rights? And this child was of an age, right? He was old enough to be able to consent to adoption. So would that not be important for the department to, and for the judge to find, given the situation? And I guess my question to you, maybe you don't know the answer to this, is do you know what the policy is of the department with respect to whether, for, again, a child who's old enough to understand what the proceedings are, to if the department's seeking termination, that they would have a conversation with them before?
I could not say if that's a policy. I did want to correct something. I just did misspeak. The judge did credit the department's assessment that termination would not have an impact on his life. And then with regard to your question, Justice Tan, about the department had not raised the issue of adoption with child, but it does not appear from the findings that any other
conversation,
custody arrangement was discussed. Seeing that I'm over time.
Can I just ask, you referred to a finding about the child being aware the father wasn't in touch, perhaps because of some paperwork issue. Can you let us know through an argument, through a letter afterward, where that finding is? Please.
Yes. Yeah, certainly I can do that.
All right, well, thank you. That was well argued. We understand your positions. It's obviously a very important case. I want to thank our court staff today for their assistance in organizing the sitting. Thank you very much, everyone. Have a good day.